We're all set.
We are all set now.
Excellent. Okay, good morning, everyone. This is a convening of the Massachusetts Gaming Commission. And because we're employing a virtual platform, I'll take a roll call. I note that Commissioner O'Brien will be joining us probably just around 10:30 or so. So good morning, Commissioner Hill.
Good morning.
Good morning,
I'm
Commissioner
here.
Skinner. Thank you. Yes. Good morning, Commissioner Skinner.
Good morning, I'm here.
Great, thank you. And good morning, Commissioner Maynard.
Good morning, Madam Chair. I am here.
Excellent. So we'll get started. I think we had meetings every single moment of every single day this week. And so for that, I want to express my gratitude to my fellow commissioners and to the entire team. I know that you're working beyond our public meetings, and I thank you for all of the efforts that are going into not only the work that we're going to be discussing today, but the varied work that we accomplished over the course of this past week. We are not bored, certainly. So we're going to get started. Today is November 17th, public meeting number 403. We do have, I'm calling the meeting to order, and we do have some minutes, Commissioner Hill.
Madam Chair, I would respectfully request that we do these at the end of the meeting, and I will remind you. I always want to make sure the other commissioners don't have any issues with what we have put forward. And knowing that Commissioner O'Brien will be joining us a little later, I thought maybe we could wait in case she has an issue.
I think that's right, because I believe they, these minutes were, Commissioner Skinner, you were here for those minutes, so great. Okay, good, fine, but do remind me.
I will.
Thank you.
And thank you for that request. Thank you.
Yes, and thank you to the legal team for getting them ready. Excellent job. Okay, so we have a good number of regulations to turn to. Todd, I think we can go right ahead with the racing. Commissioner O'Brien was particularly concerned about 4B, that we address perhaps the issues around minors when she is here. Let's see how we proceed, and then we'll talk about reordering if necessary. Okay.
Okay, good morning, Madam Chair, Commissioners, and all. We're going to jump right in, and Associate General Counsel Judy Young will take the first one. This is 4A on the agenda.
Good morning, Madam Chair. Good morning, Commissioners.
Good morning, Judy.
All right, so coming before you today, we have, excuse me, we have 205 CMR 2.01. That is the application for a license to conduct a racing meeting by a new operator. This is coming to you for a vote of finalization. The first time it came before the Commission was on September 15th, 2022. As previously stated, this is an entirely new regulation aimed at codifying various points of 128A that pertain to what an applicant who's seeking a racing license must submit to the Commission. So essentially, this regulation is intended to cull together that information and provide a little bit more clarity for future applicants. I'm happy to walk through the regulation with you or screen share at your preference, Commissioners.
I do think we should mention that we received a public comment from Ms.
Yes.
Kellogg. Ms. Kellogg has assisted in her comments in the past. Did everybody have a chance to see that comment? It is in the packet.
Yeah.
And
I love screen sharing, Judy. So
Okay.
if the chair would allow that to happen, I would be grateful.
that would be great, very good
Okay.
as we walk through.
All right, certainly. Give me just one second. All right, let me know if the size is all right. I can make it bigger or smaller at your preference. Good. Okay, I see a thumbs up from Commissioner Maynard. Okay, so here we have the entire regulation. I do want to point out just a few things that are helpful before we kind of get into the comment that we received. Section 1 states the requirements or enumerates them in the letters beneath and below. And it also allows the commission to require specific information from the applicant, but specifically states that this is not all that we can require from an applicant and allow them to submit. So it's kind of the floor and not the ceiling, so to speak, commissioners. So starting first with the name of the applicant, a $300 licensing fee. One thing to note is that within MGL 128A Section 4, there is another calculation for licensing fees, but it's not listed here, as the other licensing fee is for applicants who are seeking renewal. And it uses a very handy calculation of the previous year's racing handle. So that's why it's not listed here. But applicants seeking a new license simply pay $300 as a flat fee. Moving on, we ask for the location of the racetrack, calendar year and days in which an applicant wishes to race, the hours of the day. All of this is pulled from specific places within 128A, a feasibility study, and notably, as the comment that we received, the approval and information of local support here in 128A Section 13. Moving on to Section J, we ask the applicant to discuss and share the evaluation of suitability and qualifiers similar to what we do for gaming and soon to be sports wagering licensees. Down in Section K, we ask for information relative to the public interest and benefits association with the racing meeting, including purse agreements, agreements with horsemen's associations, local support, and any sort of intention that they have of working with MBEs, VBEs, and WBEs. Next, we go on to request information relative to parimutuel wagering and simulcasting. And then lastly, an attestation asking the applicant to comply with any licensing requirements that the commission bestows upon them, an affirmation that what they're saying is true and that they intend to abide by every statement and promise that they've made in the application. And lastly, in Section N, similar to Section 1 above, any other additional information that the commission can prescribe. So this is within the statute as well, but we did want to include it in the application here. Notably, just if there was any other information that the commission wished to receive from an applicant is aware and not kind of caught flat-footed or surprised that the commission asks for more information. So with these two statements, or with these two areas here, both in 1 and N, we do feel that this regulation is ready to go forward. We appreciate the significant public comment that we received from Mrs. Kellogg. However, we are confident that we don't need to necessarily propose changes to the regulation as it lies, as the commission can ask for more information many times throughout this process.
Commissioners, questions for Judy? All set?
All set, Madam Chair.
Thank you. What stood out to me in the public comment was the reference to the October 1st deadline and the suggestion that the commission require the applicant to have satisfied all of the legal conditions precedent prior to that deadline. And so that may require further discussion among commissioners and further analysis among the team. But I think that that is something that we should be paying particular attention to going into this next application season. I think Commissioner O'Brien also suggested that we take a look at that. So I just want to make sure that we don't lose that in this regulatory promulgation process.
Certainly, and I think that is definitely a fair consideration, and I would be willing to table a vote on this. If we did want to wait for Commissioner O'Brien to kind of rejoin the meeting and we could discuss that portion, Commissioner Skinner, or bring it back at a later meeting, it's ultimately, your decision.
Judy, is including that requirement, is this the set of regulations where it would go, or is there another regulation that it might fit neatly within?
Well, completeness is mentioned within the statute, within this regulation, within the first couple of lines, as well as 205 CMR 14.02. Give me just 1 second to double check that reference. 14.01, that pertains to supplemental procedures for licensure for horse racing applicants. And so within those three areas of law, the commission specifically has the discretion to deem an application complete based on what an applicant submits. However, within 1401, and I'm happy to pull up that site for you so you can have a look at the language, commissioners. The commission does have, sorry, I'm getting a cat on my lap. The commission has the ability to deem an application for a license complete as of the first date it's filed, but also has that ability and authority and discretion to require applicants to continually submit more information before deeming an application fully complete and ultimately awarding a license. So this is kind of the power to just request more and more information, but ultimately, I do feel that there is probably some discussion that the commissioners would like to have regarding, local approvals and 13A in regards to the licensing process. So I'm definitely willing to wait for Commissioner O'Brien if you would like to have a deeper discussion, Commissioner Skinner.
Well, I defer to the chair and my fellow commissioners. I'm just one of four right now, but I would suggest we do wait and hold off because, we have had some unusual events over the course of the past couple of weeks as we reviewed the new application that was submitted. So I would suggest we hold off. But I would like to hear from my fellow commissioners.
I think that the regulation and the regulations that we've been working under have covered us in terms of how we have managed the matters before us now, and would give us the flexibility to address the applications that could come to us in the future. And as I understand it, do reflect the statutory mandate. I'm happy to wait for Commissioner O'Brien. I'm just also very cognizant of the fact that I want to keep things moving. I don't know, Commissioner Maynard, Commissioner Hill, do you want to weigh in?
I think I saw Commissioner Maynard raise his hand first, so I would defer to him at this point.
I do think that, thank you, Commissioner Hill. I do think that it's a significant issue that the commissioner just raised about the fact that we will want to do something going forward with deadlines. I do think that this regulation captures that. And I was also under the understanding yesterday in scheduling when Commissioner O'Brien was discussing her availability today that this particular regulation probably could move forward, but maybe I misheard her when she said that. But I do share Commissioner Skinner's concern about next season, but we do have the current season in front of us, and I think there's enough flexibility in this regulation to do what we're trying to do, and do what Commissioner Skinner wants to do too.
For clarification purposes, my request isn't to necessarily wait for Commissioner O'Brien. I just am more looking for a substantive discussion as to whether or not we should include language as we're reviewing this regulation today that speaks to the October 1st deadline, and whether the legal condition precedent that local approval be obtained should be included as an amendment to this regulation. And if not, if we're not prepared to discuss that in depthly today, what would be the process whereby we are communicating with the public that there's been a change to prior process? How would we communicate that if we rely, Judy, on the language that you referenced earlier that gives us the authority to set parameters for application submission?
So I think that the commission, I feel, I definitely don't want to feel like I'm beating a dead horse, but the commission does have a large amount of discretion and authority here. As we prepare for an upcoming racing seasons, we will go through the exact same process that we did in previous years. So we will bring forth the racing application for a new applicant again. And within that racing application, we can add additional language or questions for applicants to answer, hopefully a little bit earlier and providing them a bit more time. But also we can ask, and I'm trying to find the exact section within our racing application now while I speak, but we can ask them if they have certain levels of approval. And we can go beyond a yes or a no, but also, require more information from them if where they are in the process, if they aim to have local approval, what sort of things that they've already achieved, Commissioner. And I think within that application and utilizing these regulations, again, the floor and not the ceiling, I do think that the commission will be able to receive enough information prior to submission from applicants, but again, requiring more before that final deadline of making a decision.
May I, thanks, Judy. May I just add something
absolutely.
on this point? So I think procedurally where we are on this reg, Commissioner Skinner, is that the vote today is a vote to finalize it. So if you vote on it today as is, it will be finalized in this form. It will take a little bit of time for it to get through the process because racing regs go to the legislature before they become final. So to the extent any revisions, the commission wanted to make any revisions to this reg in the future, it might be best to wait until this version is finalized and then sort of bring it back for revisions, and we can kind of go through it again at that point. That's one way to do it. Another way to sort of codify the thoughts that you're talking about of deadlines for specific statutorily required elements would be to do it in a revised application. So we could either bring this reg back in the future and revise it, or amend the application. Those would be my two suggestions.
Does anybody have a memory of Commissioner O'Brien asking that on the public record that this be tabled? This reg be tabled altogether?
Yeah. Madam Chair,
Yes.
I think I was thinking the same way Caitlin was thinking, to be honest with you. I think there's plenty of opportunity for us to make revisions with the process moving forward if we were to be able to vote on this today. So I am of the feeling that we have discussed this regulation quite a bit over the last few months. The legal team has heard what we've had to say, and they've made the changes, I think, in a very good way for us to be able to move forward today. But Commissioner Skinner, there will be opportunities for us to be able to make revisions should there still be concerns moving forward. And I think it's 1, 2, or maybe even 3 different steps throughout the process that will make that happen, or could make that happen if we needed to. I think there's plenty of opportunity to bring this issue back up again in the future and to make changes. I'm ready to move forward with this one.
Commissioner Skinner, I wanted to make sure that I hadn't missed anything that Commissioner O'Brien had raised. I would follow the recommendation of Councilor Monahan and take the advice of Councilor Young that we have that discretion under the statute, and that if need be, we revisit, if that will work for you.
It does work for me. Given, again, as you noted, the advice of counsel, I am satisfied that we will have another opportunity to address this issue.
Okay.
Thank you.
Okay.
Madam Chair, if anything I've learned through this regulation process over the last 6 weeks is that we can always bring back any regulation should we see that there should be an issue that we could change. And I believe we did one within a week. a few weeks
Yeah.
back.
Yeah,
So I'm
if it-
comfortable with moving forward.
If it gets fully promulgated, we always have the right to amend, and that means more work, I suppose. But, that's reg review, and reg review can start the day we finalize. It's because we get smarter every day. So I appreciate that, Commissioner Hill, and I appreciate the legal team chiming in on this matter. With that said, do I have a motion on this particular, you want a motion, correct? Judy, are you?
Yes, Madam Chair, we are seeking a motion today of finalization and approval. However, I just did want to clarify, as Caitlin mentioned previously, because this is a racing reg, it will go and be filed with the clerk of the Senate for approximately 60 days before becoming finalized and filed with the Secretary of State. So we estimate that this regulation will become final sometime in mid-January or early February 2023.
I'm ready to make a motion, Madam Chair.
Thank you very much.
I move that the commission approve the amended small business impact statement and the draft of 205 CMR 2.01 as included in the commissioner's packet and discussed here today. And further, that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Give it to Commissioner Maynard. And then are there any questions or edits on that? Okay, Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
I vote yes. So 4-0.
Thank you, commissioners.
Thank you. We're all set on that one. And then you'll just keep us apprised on the legislative review. Again, until we have Commissioner O'Brien here, we will skip over the minors. Legal team and I guess Attorney Carius has turned off his video, but does it make sense? I'm trying to imagine what Commissioner O'Brien would be most comfortable with us addressing as a team of 4 rather than a team of 5. I don't want to put you out of order in terms of the order that is set forth in the agenda, because I know that it was intentional. Is there one? I had wondered if the operation certificate was one to go for.
Madam Chair, I was here and listening. I'll defer to Todd and Caitlin, but I do know it's 10:26. So if you want us, we could start talking through any of them, and I believe Commissioner O'Brien will join shortly. But operations could make sense to go first. Todd, Caitlin, do you disagree?
I think that works. Yeah, I don't. That's as good a one as any, I suppose. I guess would be my answer.
I also believe we're not asking for a vote today. Caitlin, correct me if I'm wrong on definitions. So we could talk about the overall approach to definitions, perhaps as a starting point. And that way, yeah.
Let's go with definitions.
Okay.
Thanks.
Great.
And then we'll go back up to occupational licenses. I think that she should be part of that discussion. Commissioners, do you agree with that? Okay, thank you.
All right, so I'll give a quick introduction about the definitions before I turn this back over to Mina. So as you may remember, the commission voted to promulgate a definition section by emergency a while ago now. And so it's been moving through the emergency promulgation process, and there will be a final vote on that regulation on December 1st. In advance of that final vote, and when there is still time for some public comment, we wanted to make a few tweaks to some of the definitions and add a few definitions. Now that we've promulgated additional regulations, there are additional definitions that we'd like. So that's what we're bringing forward for you today is some additional definitions, some tweaks to the definitions. And what we're asking for is not actually a vote on the reg itself, but a vote for your approval to post this revised version of the regulation on the website for comment before we bring it back to you for final vote on December 1st. That's a little complicated, so if there's any questions on that, please let me know. But otherwise, I'll turn it over to Mina to walk through the changes.
I think, Mr. Curious, we're starting on, if we do the red line, is it packet page 160?
Correct. Madam Chair.
The red line is at 160, yes.
Okay, so if there's no questions on the process, let me just briefly explain what we did here. This is probably not one that lends itself to telling you about every single red line. But what, as Caitlin mentioned, we had done the emergency regulation initially to capture definitions that were needed for some of the first batches of regs that went through, vendor regs in particular, and then some of the licensing ones. As we've drafted a few, you've probably gotten sick of us saying, that's a defined term that you'll see in 202 when we revise it. So here we are. These are some of the defined terms in 202 are added here. We also took the opportunity to add in the remaining definitions in the statute that are going to be defined with reference to the statute in working with GLI. In the background, we'll continue to work with GLI and the legal department in A&K to make sure other definitions in additional regs come up, but these were the ones that are sort of ready to go at this point for public comment. Key ones that I will just quickly cover that are not purely just defined as in the statute.
Mina?
Yep.
I'm sorry for the interruption. I'm going to ask that you share your screen. I'm only working with one monitor today.
It's okay. Let me do that. And let me try to do that without messing everything up. So give me a second.
Thank you.
Otherwise, somebody else can share the screen. Legal, perhaps to help out, Mr. Macarius. Page 161.
Yeah, I mean, I'd be happy to do that if that'd be helpful. Just say the word.
162.
Oh, you got it. Okay.
Yeah, I got it. That should be good. Just was making sure you weren't getting anything else. That's always
Just need to increase the font if you don't mind.
let's see. Is that better?
Thank you.
No problem. All right. So some of the key ones that are added here and sort of where they come from. Annual assessment. This has to do with the licensing and fees for investigations. This is the way that the sports wagering portion of the budget gets covered. It tracks the annual assessment process under gaming. Most of the other ones on this first page you'll see are defined with reference to the statutory definition. House rules is not defined in the statute, but is described in 23N section 10, and that's where that tracks the language and how it's described there. We get some of the more interesting ones, perhaps, on this next page, where we define throughout. We've had issues, as you know, trying to make sure we define the different ways in which sports wagering can be accessed. One is a mobile application. This is a definition developed in part with the experience from GLI and a little bit of wordsmithing, but the idea is to keep it broad for a mobile device. That's the mobile application definition. The operation certificate, this definition is almost identical to the one in the 100 series. It's a certificate of compliance issued by the commission to an operator. We have, generally speaking, we have not cited back to other regs in the definition unless absolutely necessary. So that's why you don't see a reference to the 251 here, but it is that operation certificate. Going down the list, again, a bunch of these are just coming from the statute. Qualifier is a term that now appears several times in the suitability process and the sports wagering vendor and occupational licensing process. So that is where that is where that's the case. We've wanted to capture it here as well. And The two that I would call, or a couple that I would call your attention to, sports wagering area. And then I'm going to just scroll down a little bit to sports wagering facility. You may be wondering, or we have seen some questions internally as we talked about that. Do we really need both, and what's a distinction? And the distinction is a sports wagering area is intended to be the area of a gaming establishment already licensed under 23K that is used for sports wagering. A sports wagering facility is a sort of standalone sports book. So they're both in-person wagering. The reason for the distinction has to do with language that was changed and is proposed to be changed in some of the 100 series regs to clarify the Bureau or the Commission's authority for enforcement over certain aspects of the facility, or recall that of gaming establishments. And in areas where, for instance, when we get to a surveillance reg, we are saying we're likely to suggest that a gaming establishment has to be able to capture not just the gaming area, but areas where sports wagering is happening. That's where this definition, sports wagering area, might come in handy, even though it might be within the gaming establishment's physical parameters. So that's the reason for the distinction between the two. It also is attempting to address, in part, the conversation we had last week or the week before about access to sports wagering equipment within an area, for instance, at Plain Ridge, if it were set up that way.
Madam Chair, may I interrupt for a moment?
Yes, thank you.
Mina, I think you minimized your screen, and I'm only getting half of what you were showing.
My apologies.
You know what it is? Yeah, you would just have and now if you could just expand it a little bit. Yeah.
Better?
Yeah, much better. Thank you.
Sorry about that. I can't see what you're seeing. I can on your end, unfortunately.
If you increase the font a bit, I think it says 200. I think it's because there's something on this. It's because it's a red line or something. That's why it's still small, but it's good.
Yeah, it's good. Thank you, Madam Chair. And Mina.
Thank you.
Yeah, you're welcome. So did you get a chance to see, Brad, if you scroll down, Mina, he'll see the sports wagering area in sports wagering.
Yep, here's sports wagering.
Facility though.
That's facility. Sports wagering area is up here. Unfortunately, it's just on different pages, just because of the order.
Yep, I got it. Thank you.
I see area, I just don't see facility.
Right, they're on different pages, so I have to show them separately. That's all. So why don't I just read these two out loud? A sports wagering area means a part of a gaming establishment operated by a Category 1 sports wagering licensee for in-person sports wagering. And then on page 162 of your packet at the is sports wagering facility, a facility operated by a Category 1 sports wagering licensee.
Oh,
Category 2.
Yeah, I'm sorry, Mina.
That's all right.
I can't figure out that F follows A. Thank you.
Well, I'm just glad it did. That's actually
It's a copy now. Thank you so much.
That's okay. There's also in here a definition of sports wagering kiosk, which is a fairly straightforward definition, but again, necessary to explain what these things are because they pop up in the regs quite a few times, and it's a self-service facility. The last key definition here is sports wagering platform, which is a broader definition than a mobile sports wagering app. Obviously, that would include a desktop platform, a website, etc. I'm not sure if this will be the only place in the entire CMR where the word widget is used, but if so, we'll be proud to have inserted it into the lexicon.
Mina, I might flag sports wagering vendor, the slight change to that.
Yes, I'm sorry. Thank you, Caitlin. Yes, slight change to sports wagering vendor. Helpful comment from folks at GLI and also in the process of amending the 244 reg that the testing or certification labs are not exactly sports wagering vendors. They're certified separately as testing facilities, so it didn't make sense to include them here. Of course, if you recall, within the sports wagering vendor regulations, there is a catch-all. So if for whatever reason, there is a vendor who's doing peer review or something else and isn't going to be licensed under 244, which I think we're going to come back to in a little bit too, they would get captured that way if necessary. But it didn't make sense to have them as a presumptive category here. Thank you, Kayla.
Can I ask a question about that? And it's very spontaneous, so forgive me if it's not well thought out. But Commissioner Maynard, you raised the issue during our roundtable or sports wagering vendor.
Mm-hmm.
A vendor under our statute as an operator sports vendor, it's always under the control of the operator, correct, as an agent, regardless of however we deem it for purposes of suitability. A vendor would be under the control of the operator. And the reason why I'm asking this, you also have down some of the types of services.
Mm-hmm.
One of the concerns we had with respect to advertising and marketing, and I know that we did address that third-party marketing piece that Commissioner O'Brien has raised in the past. We want to make sure that vendors have to comply with our expectations around advertising and marketing, particularly around social media. And that I know this is just definitions, but I'm marking this as an issue that's come up. I feel like we got it covered.
We have, Madam Chair. We talked about this a little bit, and I believe this when we talked about 234. I know we talked about it as a drafting team quite a bit. It is third-party marketing entities are listed here because we do imagine that there may be. What we don't want to have happen is for an operator to say, well, we're not the ones putting the ads out there. We give our content to a third-party entity, and they buy ads and do whatever else for us. And so, yes, the vendor would, if they meet the other criteria for regulation in 234, may need to be licensed or registered as a vendor as well. And in addition, because as you pointed out, all of this assumes at least contractual control, if not more so from the operator, if they are not controlling their vendor in the sense of having them comply with whatever marketing requirements you end up having, that would be, that would ripple back onto the operator and the vendor as a violation.
That's really helpful me. Questions for me on that point. I know it's a little bit outside of definitions, but so it would be, I know we've got the third party marketing, and it would include any vendor that has any control over any lists. The operator must make sure their vendors comply. It falls back to the operator.
Correct. Yeah, and this, I don't want to go too far down this because I think one of the next steps from the roundtable is going to be what the commission's desire is on sort of how to guide the what to do on marketing controls. And one of the questions will be how to make sure it actually happens. It's and what's an adequate level of operator control over advertising.
Yeah. And so the definition, back to definitions, a vendor is broad enough to capture those concerns, correct?
Correct.
Okay. Commissioners, are you all set on that?
Thank you, Madam Chair, for raising that.
You all set, Commissioner?
Stay here, actually.
Okay,
Madam Chair, is there any language that you're thinking that we could add to that definition to ensure? I mean, I know it's brought up in other regs, but here we have a nice list. Can we add anything else to it?
Do you want to put advertising?
I think with the discussions that we've been having, I'd like it to be a little more clearer. But I'm also not a legal eagle, and maybe this language does that.
I don't think it hurts to spell it out, right? I mean, this is not an exhaustive. Yeah, it's not limited to, I see that in the language, so obviously it's not an exhaustive list, but it does make a statement that we are concerned about it, because I think all of us have raised that concern.
Commissioners Maynard and Hill, I think I just want to be clear on what we'd be adding, because I think the third-party marketing entities is very broad. We could certainly add third-party advertising and marketing entities to make it, in case there's any distinction between the two words that might catch somebody. But I think when you're talking about how those entities start operating, I would be hesitant to put it in the definitions here. For instance, just to use one of the examples I think the chair brought up is social media marketing. And I imagine when we get to thinking directly about how that's regulated, we'll have to address the issue that my colleague Christina brought up about the Communication Decency Act, of how far we can go to regulate third-party content on social media. There may be some things where we can say the operator shouldn't be pushing out stuff, but if how much a third party that they contract with promotes, social discussion of it, we'll have to just think about more. So I guess I would rather keep this category broad to not accidentally make it seem like we're only focused on one piece, if that makes sense.
And then address it when we're going to get a body around advertising and marketing.
Yeah, although the word advertising, if that feels like it's
what
an
would that
additional
hurt?
certain problem.
Yeah.
That would hurt
Madam
anything.
Chair, if you would be okay, I would love the word advertising as part of that, Mina, if you think it would be okay to do.
I don't have a problem with that. Caitlin and Todd, I assume not either. We can just add that in.
So, Mina, this is Commissioner O'Brien. My only thought on that is to do an and/or. So it doesn't look like the entity has to be providing both to fall within the list.
Okay, can I just make it an or out of?
Or, yeah,
Okay.
to keep the word count down. Yeah.
Well, it's not so much a word count. It's a weird allergy to and/or that we can talk about at some point from my own legal mentor.
Like the
But that's
Oxford
it. Yeah. So no, but we can certainly do that.
Commissioner O'Brien, welcome. We had a bit of a discussion around the horse racing, and it did pass with the idea that should we desire amendments down the road, we would be able to make that. But that will now go to the legislature for their review. As you know, with respect to horse racing, we have that additional process. So, and Todd, Judy, and Caitlin can bring them up to date on that. So, welcome. Good morning. May the record reflect that she is here.
If there's nothing else on the vendor definition, I'll move on to some of the remainder of this one.
Thank you for that. That's really helpful, though.
No, thank you for the helpful discussion. As always, it's good to have it and understand what the thought process is on it. Last new definition that is not a 23N repetition here. This was suggested by GLI and again, this one is not one that you'll see used just yet, but it will come up as we start thinking about house rules and some internal controls. Different categories of wager may come up, and this definition just is intended to capture that. It also includes an example, which is done sometimes as a way of clarifying in the CMR, and I think it makes sense here. So that's it for the definitions. As Caitlin said at the outset, I don't believe we're asking for a vote today, other than a vote to publish this with the one edit that we discussed for public comment and we'll obviously also be keeping an eye on this list as we go forward with other regs.
Any questions?
Madam Chair, I have a process question. I thought we needed to take a vote to move these forward to the public. Am I wrong about that?
I think it would be helpful to have a vote. It's not a vote on the final reg or anything like that, but it would just be a vote to allow us to publish it in this form for comment, and then we will bring it back to you on December 1st.
So this accommodates our desire to just have the public weigh in if we vote, and then we could react on December 1st. Does that work for you, Mina, then?
Oh, absolutely, yes, yeah.
Okay, great. Commissioner O'Brien, did you have a chance to review the definitions, or do you have any questions for Mina, seeing that you came in? I don't know at what point you joined the conversation.
I came on at 10:30, pretty much on the dot. No, in my understanding, meaning, correct me if I'm wrong, but these will probably be revised necessarily as other regs are rolled out, right? The definitions. Not necessarily striking what's in there now, but potentially having to add, right?
Correct.
Yeah. Okay.
But there are terms right now that haven't been used, so they're anticipating as well, which is great, right? I mean,
yeah.
Okay, excellent. So commissioners, if you have no further questions on this, do we have a motion?
Madam Chair, I just have a process question, please, or more of a statement. I think the practice of voting to allow these regulations to move forward by posting on the website is a new process. I understood, correct me if I'm wrong, Caitlin and Todd, I understood that the regulations were being posted on the website as they were drafted to allow public comment. So I'm a little confused as to why for this set, you're seeking a vote to post on the website.
Sure. So these have been posted. So when these were passed originally in a sort of shorter format, they were posted when they passed initially. They've been up for public comment, and they're moving through the promulgation process to a final vote on December 1st. Because of the emergency process, because of sort of what we're doing right now, we wanted to make some changes to them before the final vote on the 1st. So this is almost like an interim change that doesn't require a final vote or an initial vote, but we're just seeking your approval before we change it and put a revised version on the website for further comment.
Got it. Thank you.
Is that helpful?
That's helpful. Thank you.
Okay, great. Okay. With that clarification, do we have a motion?
Madam Chair, I would move that the commission approve to post for public comment the draft 205 CMR 202 as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner Skinner. Okay, any further questions or edits? Right. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner, did you?
I'm sorry, I didn't hear you. Aye.
Well, that's okay. I wasn't sure if all of a sudden you were on mute. Yes, we recorded your aye, and then Commissioner Maynard.
Aye.
That's 5-0. Thank you.
Your microphone, Madam Chair, your microphone may be coming in and out a little like Karen's does.
Thank
Yeah, I
you.
think when you move back ever so slightly, I think it drops.
I think I can change it. Let's see. And Mills, you can let me know if I'm doing this right. We've got the eco canceling speaker session on both. Let me know. Thank you, because it can be a little bit of a challenge. All right, so then I guess then we could go back. Does it make sense to go back to 4B now? Legal, Todd? Oh. All right.
Yes, that sounds good. Just
Okay.
have one moment here. So we're on to 205 CMR 250. This is the protection of minors and underage youth.
Which is at the top of our packet. If I'm using the packet. Page 28, is that right? After the memo? I think.
That's correct, Madam Chair.
Thank you very much. Okay.
So just by way of refresher, this did come before you once before November 10th. It's back for further discussion. Without further ado, I think I can turn this one over to Dave and Annie Lee from A&K to discuss these particulars.
Thank you, Todd. And so just to recap this for everyone, these were the regulations that we previously presented last week on the protection of minors and underage youth from sports wagering. The content of the regulations is largely unchanged except for sort of two major edits, or not major, but just two edits that should be apparent to you on pages 28 and 29 and 30. And so the first one that you'll see on your screen is that to address concerns about kiosks getting placed in sort of bars, specifically the example that we were looking at is what if a horse racing facility wants to put kiosks at the bar? How do we prevent minors and underage youth from engaging in sports wagering in those scenarios? And so we've expanded 250.01.1 to include the prohibition of placing a bet at a sports wagering kiosk. And then to sort of conform the rest of the section, we also included in 250.01 subsection 2 a provision that the written policy that sports wagering operators will submit to the commission for approval will include specifically a policy, practice or procedures that are designed to keep minors and underage youth from engaging in sports wagering at these kiosks. So that was the first substantial change. The second one is if you move to the packet pages 29 to 30, we removed 250.05, which we had previously added to mirror the sanctions provided in 133 and 233 regarding sanctions against a sports wagering operator for violations of the voluntary self-exclusion regulations. After some discussion with the IEB, we came to the conclusion that this section is better left out to afford the IEB the same discretion to enforce underage, minor, and youth prohibitions in the same way that they're enforced in the gaming context. So we understand that in the gaming context, the IEB has discretion to evaluate sort of the severity of sort of the offense and the corresponding sanction based on a totality of the circumstances. And in order to allow the IEB to enforce these regulations in the sports wagering context in the same way that they enforce them in the gaming context, we thought it was best to conform these sections and just remove 250.05 since that had never appeared in 150.05.
Annie, I had wondered about that. I feel as though there is a conflict between the two statutes, that the sanctions can be imposed by IEB, and there's a whole process under 23K where that process is for sports wagering is actually addressed to be by statute for the commission to do the sanctions. So, and that's actually a somewhat significant because the current process, if the party that's having a sanction imposed on them agrees with the sanction with IEB, they can no longer appeal to the gaming commission and then ultimately a court. And so the fact that the sanctions are to be imposed by the commission for sports wagering means that I would assume we would use IEB for investigatory purposes and analysis, but that the first stop for the sanction would begin with the commission. But I haven't looked at those provisions for a bit in the statute. I might be wrong.
I see. Dave, do you mind addressing this?
I wonder, it may make sense to have Director Lilios weigh in here because what we've tried to do is make the IEB's authority with respect to underage sports wagering mirror its authority with respect to underage gaming in a gaming establishment, which based on feedback from the director, she was content with the mechanism they had in place there.
I always welcome Director Lilios. I think that makes sense, but I think that the sanction that we could rely on them in the investigatory process, that the sanction itself would be imposed under 23N, regardless of whether it's a minor issue or otherwise. Let's start with the commission.
Chair, if I may, I think the edits that were done in this version of the reg are primarily meant to establish the standard for infractions for underage. The prior version said that in order to amount to a violation, there had to be a knowing and reckless standard. The standard that the IEB has used under 23K has not required that high standard of proof. It's more like Annie explained, a totality of the circumstances standard requiring substantial evidence in the end of the infraction. The question you're getting to, Chair, of whether the enforcement mechanism under 23N can be delegated to the IEB or must rest with the commission. There's a lot to unpack there. And we have on our agenda setting as under review that question with respect to vendors. And it's my suggestion that this be visited, that authority, the enforcement authority, which implicates also for the licensee, what type of review the licensee would be entitled to. If the commission is the primary enforcement mechanism, the next layer of review then would be the Superior Court, as opposed to if there were internal agency review with a hearing officer, then review by the commission. So that is a larger question. I don't think that is addressed in this draft. I think what this draft is intended to do is to address that standard, the knowing and reckless standard. But this question of the enforcement mechanism and whether, what use the commission will utilize the IEB for is a matter that's under review with respect to vendors and is I think the same issue here with respect to the operators.
Can I ask, in the statute with respect to the standard, where was the language knowingly or recklessly?
It's from a regulation on the gaming side with respect to violations of voluntarily and involuntarily excluded persons. So that was lifted. So if the operator lets a VSE in, a knowing and reckless standard has been applied. Same with an involuntarily excluded person. Minors were treated differently.
Are minors a higher standard or a lower standard?
The standard of proof for the IEB is lower. We do not have to prove for minors that the operator knowingly or recklessly allowed a minor onto the premises.
Okay.
And just to add there, excuse me.
I guess my only question would be, sanctions have been taken out of this particular reg. I think we just need to eliminate that at the top, but that we're going to be addressing sanctions. I didn't know it was tied into the vendor issue, but I do think that the commission needs to have, be really well informed as to the difference between 23N and 23K. And I think commissioners, you should be aware of the fact that it is treated differently. This is certainly an issue that has come up in the course of my 3 years as to the process. So, then I guess we stay tuned to those, but that I understand now that we're putting them into a completely different reg, Caitlin, and I'm forgetting, and Annie and Dave. We're going to put them in a different reg altogether.
Yes, that's the plan.
Thank you. All right.
So
good, Dave.
the only other thing I wanted to point out, there is the insertion of the word solely in the very first paragraph. And I wanted that inserted when I was reading it because there's the possibility you might get someone under the age of 21 who's allowed to go in and sort of test software and that sort of thing in any of these apps or kiosks. And looking at the language in 150, trying to make sure nothing was going to get left out, wanted to make sure that there was no backdoor for anyone under the age of 21 to have a claim of being in there appropriately and then betting. So while the chance might have been minuscule, I think that word was put in there to make sure you could have somebody under 21 who's actually on the tech side working and testing these things, but it was going to protect a backdoor avenue to argue they had the right to be there. All of the other things I think now sufficiently address the concerns that I raised last week on this, and particularly the striking of 5 and putting it in a different section, because I think trying to merge the VSE standard into this was not going to give us the result that really was going to be warranted and to protect the minors that we were looking for. So I thank the team for the work they did on this in the week in between. I think it was necessary. So I think it's in a much better spot today.
Excellent. So are there any other questions then for Annie or the legal team or Mr. Mackey?
I guess I have a question, Chair. How did, when 250.05, when it was drafted, what was the, I want to understand why it was drafted and why it was taken out, because I wasn't subject or privy to the conversations on how it was drafted or how it was taken out. So I'm interested why it was drafted the way it was when it was put in and why it was taken out. I just heard Commissioner O'Brien explain a little bit of why it was taken out, but I don't want to abrogate any authority the legislature gave to the commission. And there's obvious differences in the statutes. If the legislature would have wanted to Control C, Control V, they would have done that. They didn't. So I want to make sure that our regulations do match the new statute.
And Commissioner Mader, I'm happy to provide a little bit more context on why we initially drafted this. So we initially drafted 250.05 because, as you'll recall, we were drafting 233 on voluntary self-exclusion and the protection of underage minors and youth from sports wagering at the same time. And so looking at both of these regulations as sort of the responsible sports wagering regulations, when we were drafting 233, we sort of thought about what would be appropriate and what would make sense to also include in 250, because 233 includes a lot more provisions than 250, or I should say 133 includes a lot more than 150, since those were the initial inspiration for this. And so when it came time for 250.05, we noticed that there was a lack of sanctions in 250 and in 150. And so looking at sort of the counterpart in 133 and 233, it sort of made kind of good sense to us at the time that to the extent that there are sanctions for failing to abide by VSE obligations, there should also be parallel sanctions for failing to abide by any regulations regarding the protection of underage youth from sports wagering. And so that was the intent, was really to sort of conform 233 and 250 as much as possible in the recognition that these two regulations are designed to promote responsible sports wagering. Dave, I don't know if you have more to add to that.
The only thing I'd add to that, that's exactly right. And then, the feedback we got both at the meeting last week and then from Director Lilios is, related to that knowing and reckless standard, which I think folks felt was appropriate in the context of VS voluntary self-exclusion, but maybe not appropriate in the context of underage gaming. And so that's why we removed it here, so that the ability the IEB had with respect to finding violations of the underage, sports wagering regulations would mirror the powers that it had under 150 for regulating underage gambling in a gaming establishment.
And Mr. Mackey, I do think we probably need to have regulations that say that the commission wants to have the Bureau do the investigatory work because, we're jumping to that conclusion. Again, 23N is silent, and I don't think any of us are going to question that. But what I am cautioning is that I want to make sure that the full commission, as a body of 5, gets a chance to really discuss the difference between how the administrative penalties are assigned and how the Bureau is involved and the administrative process. I am acutely aware of the administrative process that's used now with a hearing officer, IEB. We have a policy that's been adopted by the commission. 3N is different, and that's all my point is that we want to understand. I hear, Director Lilio say there's a lot to unpack. That needs to be unpacked with all 5 of us, and not just ahead of us, because I want to make sure that the commissioners have, full awareness of the process and the implications. I don't have a position formulated in my mind, just to be clear. I just know there's a difference. Yeah, I really need the benefit of a fulsome discussion with my fellow commissioners.
Fully understood. In this version of 250 in front of you now, it doesn't address that issue. It simply addresses the standard that would be applied for determining a violation of the underage sports wagering regulations.
So it's strictly, and so it does assume what I said. I'm assuming that IEB does preliminary work on these matters. The statute doesn't necessarily assume that. So I'm assuming that the reg that's going to come to us will somehow address that silence, and that we use that resource. Is that right, Dave?
Understood.
Okay, great. Thanks. Okay. Any other questions on this? I think I'm hearing Commissioner O'Brien had raised some questions. I think we had a fulsome discussion on the issues. I think that they were addressed just as I imagined that they might be, with the additional issue around the sanctions. Anything further? All right. Can we take down the screen, please? Thank you, Annie and Ms. Lee. Excellent job. Thank you to Dave and team for its work on this. Thank you, Director Lilios, for your explanation. And now I assume we want to vote. Do I have a motion?
I move that the commission approve the small business impact statement and the draft 205 CMR 250 as included in the commissioner's packet and discussed here today.
Second.
Okay. Any questions or edits? Okay, Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Maynard?
Aye.
Oh gosh,
I think
Commissioner
you took Skinner out of order.
Well, you know what? Honestly, you guys changed places on me. Commissioner Skinner. This is where virtual gets me. It's a little bit of a creature of habit. Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes. Excellent work. Thank you for taking good care of that. All righty.
And I further move that.
Oh, sorry.
I further move that I have to do a second part. I further move that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. And I further move staff be authorized to modify chapter or section, numbers or titles, to file additional regulation sections as reserved or make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Any questions or edits on this? Okay, great. Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes, 5-0. Excellent. Thank you. Okay, then moving ahead, we've done the definitions. So we would go to, if everyone's comfortable without a break, move on to, am I right, Todd, for
Before?
Occupational license?
Oh,
Oh,
B2.
sports wage, I guess it's two, B2. Sports wagering occupational licenses?
Yeah, we can move right into B2, the occupational license one. So that's
Thank
235. Caitlin?
Hello, everyone again. So this is the second time you'll be seeing 205 CMR 235, the sports wagering occupational licenses reg. Last week, there was discussion about the majority of the reg, and we took it back to review the section of the reg dealing with specific job titles, which is in section 235.01 with GLI. We've received some input from them, and we may in the future receive some more input. But at this point, we're comfortable moving forward with it for a final vote, not a final vote, for an initial vote to start the promulgation process. Mina or Loretta, I'm not sure if there's anything else we wanted to say at this point.
Caitlin, I'll just quickly go through some other small edits. In 235.01B, this was just a small, the insertion of the word qualified. You heard me earlier talk about the definition of qualifier. That's to make sure that we're capturing folks who might be qualified as part of a vendor or as part of a licensee, not simply licensed or registered. So just that's nomenclature of just what category of vetting somebody might have, which would exempt them from the need to go get a separate occupational license. That's the changes in 235.01. The note in 2, Caitlin just addressed, the feedback was that generally these categories are right, and we can go through that. If in the future we need to make any other edits, we will, but that these are acceptable categories. We did take out 2, pit boss and cage manager. We had included these waiting for GLI input with the idea that we weren't sure if a pit boss at a if there is a person at a sports wagering facility, an in-person facility that functions as a pit boss or cage manager, has explained to us that those were terms of art not typically used with just a standard sports book. And instead were, but to the extent, and that at a gaming establishment, to the extent there is a cage manager for the gaming establishment who's also cashing out winnings for a sports book, they would be the same person, and so it'd be licensed anyway through the gaming licensor. So there's no separate sports book cage managers is the point.
Can I ask a question about that? Because I understood the pit boss. So cage manager, what about for like category 2?
So that what that person would end up being, as we understood from GLI, is something closer to a general manager or a sportsbook manager, as opposed to they wouldn't be called a cage manager. The terms cage manager and pit boss came apparently from sort of colloquialisms within the gaming industry. Sports wagering industry, legitimate sports wagering industry, is younger and has not adopted some of the same ones as the gaming industry. So it's just a matter of nomenclature again. So. And keep in mind, just sorry, I don't mean to, I don't know if Madam Chair, you want to weigh in. I can just want to add one quick thing. There's still right here, if I can highlight it, there is again a sort of catch-all, so that none of this is by title, it's all by function. And so if there is somebody at a category 2 facility handling money and supervising the handling of money the way a cage manager would, that person would need an occupational license as well. So there is some of that left in there.
Thank you.
I believe Caitlin and Todd, correct me if I'm wrong, but every other edit was either, this one just the word up was a repetition that was unneeded. There is no other change to this reg. And again, this reg, as I mentioned last time we came before you with it, is almost verbatim what was passed with respect to 234, but adjusted for some of the tweaks, obviously, for occupational licensing. That's all I have.
Questions for Caitlin and Mina? Commissioners, you're all set? I guess we can take down the screen, Mina, just so I can see faces.
Yep, of course, yep.
Thank you. Okay, all set? Loretta, I know that Bruce, Van, and Burke have been looking closely at these matters too. Were they all set? In terms of terminology and all, being brought up to date on that?
Yes, we've been working together. The most recent version reflects all of our comments, and we've, was explained by Caitlin, we've still developing a further list.
Yeah.
But we're comfortable with the version now for current purposes.
And getting the nomenclature up to date, apparently. So good.
Yeah.
All right. So we need a motion on this. Caitlin, correct?
Yes.
Thank you.
Madam Chair, I would be more than willing to make that.
Thank you very much.
That motion. I move that the commission approve the small business impact statement and the draft 205 CMR 235 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Any questions or edits on that? Okay. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Main.
Aye.
And I vote yes. Excellent.
And then I would further move, Madam Chair,
Yep.
that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that the staff shall be authorized to modify chapter or section numbers or titles, to file additional regulation sections as reserved, or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Thank you. Any questions, edits? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes. 5-0. I have to say my virtual platform is very busy today. Things are shifting. So
Madam Chair, may I ask for one more vote, actually? So there are forms referenced in this regulation, and those are the standard forms that we use for gaming right now, and they're attached in the packet. Loretta, if you want to explain which are which, that would be helpful. But we would like a vote on those so that those can go into effect once the reg is in effect.
Caitlin, thank you so much for remembering the forms. The forms, we're once again drawing on the forms that we use on the gaming side. This regulation contemplates two classifications of occupational licensure, and the key executive level would rely on the multi-jurisdictional and the Massachusetts supplement form. And the key standard would rely, we have a special form, the key standard application form. So those are the forms that are in your packet, and we'd be asking to adopt those forms for these purposes, for the occupational purposes.
So they were incorporated into the regulation. Is that my understanding, Caitlin? I guess when I reviewed it last night.
The regulation references forms to be approved by the commission. And so these are the forms that IEB would propose be approved by the commission for this purpose.
Yeah, I guess my question is that I thought that by approving the regulation, we approved the forms, but you want a separate motion.
I think it would be helpful just to be clear.
Okay, excellent. Commissioners, are you comfortable with that? Do I have a motion?
Caitlin, what's the actual part of the reg that references the forms?
Yeah, that's what I'm struggling.
Well, let me find that. And if someone else finds it first, shout out. But
Get bragging rights.
yeah.
3502.
Yes.
But where within is the form is what I'm looking at, the language about that.
It says every person applying shall be obligated to complete and submit an occupational license application form. Said form shall be created by the Bureau subject to the approval of the Commission. The Bureau may create different occupational license
I must be
application
looking at the
forms for
wrong
different
thing.
categories.
I must be looking at the wrong.
Yeah, so it's on page 43, 44, right?
I believe that's right. Someone correct me if I'm wrong, but that was my understanding of the reference.
That's right.
It's correct. That's the bottom of 43, top of 44.
That's my answer.
So the form shall be created by the Bureau subject to our approval, but I'm hearing that needs a separate approval, separate. That makes sense.
Yeah.
So
And then
if
what
you
are the
want-
pages in the packet the forms are actually attached in today? Just for
let
clarity.
me- And do you want separate for each, or do we do both in one motion?
So the forms start at page 51 of the packet. I think it would be sufficient to say the forms referenced in the packet starting at page 51 are the forms approved by the Commission. Again, anyone jump in if they don't think that's
No, it's the
super big
key
enough.
gaming employee standard application form, right?
Mhm.
And then the next one is identifiable by the title of.
I'm trying to find the page number for you.
Yeah.
So the
And
next one I
first
believe
one-
starts on 82, the Massachusetts supplemental form. And then the multi-jurisdictional form starts on 90.
It's so easy to scroll over. I'm just trying to get the exact title. Yeah, so the Massachusetts supplemental form, page 82, and then the multi-jurisdictional, let's say. Multi-jurisdictional personal history disclosure form. Does that help with Commissioner O'Brien?
Yeah, I think as long as we reference where the page starts in the packet and discussed here today, that should cover it. But
Yeah, so it's the key gaming employee form, mass up, and then the multi-jurisdictional personal history disclosure form. The acronym. Okay,
What's the last page?
the 91 is the last page altogether.
Mhm.
Last page altogether ends, it's long. Just as we've heard. Let's see.
I believe it's page 155, Madam Chair.
Thank you. I'm still on 120s. Is anybody comfortable making the motion?
I'm just saying, so mine ends on 153. Do I have a different packet maybe?
You might,
That-
there was an update
Yeah.
this morning to include.
Okay,
Yeah.
that's
I have it
fine.
I have it on 153 as well.
It's
there was
155 on the new
Yeah,
one.
it was an update because there were a couple of documents that were entered last night. So Crystal did update. This is, I believe, what was in front with the public right now. So,
All right, so maybe not the page references then.
so page, yeah, I would say maybe.
Okay, yeah.
Avoid confusion.
So I move that the commission approve the forms referenced in 205 CMR 235.02 that are included in today's packet, commencing at page 51, specifically the key gaming employee, the mass up, and the multi-jurisdictional forms that were discussed here today and included in the packet.
Very helpful. Thank you. Do I have a second?
Second.
Thank you. Any questions on that? All right. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. 5-0. So that taken care of, Caitlin. Thank you.
Thank you.
All right. So now, Todd and team, we looked at the definitions, but we didn't vote on them. No, we did do an initial vote. Commissioner Skinner helped on that. And then we now have the operations certificate.
Yes, I think we're on to B4 now. So this is 205 CMR 251. This is a regulation that is before you for the first time. You'll recall we've talked about the significance of the operations certificate vis-a-vis the award of the sports wagering licenses, and that when the license is awarded, it doesn't necessarily mean that an operator can commence operations immediately. They would also need to secure this operations certificate. And this regulation you're about to look at is the process and standard by which what will then be licensees will be able to get their operations certificate to get the green light to begin sports wagering operations. Mina and Paul are standing by here to walk through this particular draft, and I will turn it over to them.
Thank you.
Thank you, Todd. I'm sorry, I'm having a little bit of a lag, I think a connectivity issue on my end, but I will try to share screen again. Here we are. This is at page 165 of today's packet. The 251, there's not a whole lot more to say than what Todd has already said, that the way this proceeds is similar to 151. It makes abundantly clear that before any sports wagering can start, other than for testing purposes, which will be covered in the second section of 251, subsection of 251, you must have an operations certificate, and it identifies the sort of prerequisites in a broad sense that need to be met before an operations certificate can issue. Keeping in mind the reason that it's in a broad sense is because you want to make sure that any more specific reg that comes forward on operations is also covered, and any other condition that's on a particular license is also covered. 251.01 lays out 251.01.2, excuse me, lays out that the certificate will be in a form prescribed by the commission. That's not yet before you, but that's when you are done, that will happen. For category 1 or category 2 facilities, those will need to be prominently displayed, just as they are currently for casinos. For category 3, it'll have to be prominently displayed on a website or mobile application. The 251.013 identifies those sort of prerequisites before certificate will issue. They're identified here. Approval of internal controls, just a small tweak that we'll make before this gets approved is that internal controls will be capitalized. That was one of the new definitions you saw today. There's a listing of all employees, vendors, and non-sports wagering vendors. Note that this is consistent with 151. It doesn't say licensing of all of those. The reason for that is licensing happens separately under the other provisions. They still need to provide a list to make sure it matches up with who isn't licensed. And of course, if there's not an adequate number of, there may be folks who are still going through the licensing process that can't participate in the operation, but they may be able to open with the folks who are licensed already or registered. So that's why it's a list, and that's why I think that was done in 151. C, I won't go through every one of these, but highlighting a few of these, C, D, and E really all have to do with updates to physical improvements or security, et cetera, that an emergency response that a category 1 existing gaming establishment or a category 2 sports wagering licensee would have to do. So those are particular to the in-person sports wagering. And then F is the catch-all for conditions imposed by the commission. In the gaming side, one of the key differences between this and 151 is that there were a lot of sort of other host community, surrounding community, impacted live entertainment venue. There's a lot of references to things that just simply aren't in 23N. So this is a bit more streamlined than 151 for that reason, but still captures the key things before any go live period. I could take questions on this now, but yeah.
So, and you've gone, did you want to add more? Because I don't want to.
No, I was just going to move on to test period, so we can talk about this one for this part of it first.
You can go through the whole thing because I just wanted to clarify my understanding of the process because I have some experience with it, as does Commissioner O'Brien, but I would like to.
Sure. Yeah, so before a go live and it's open to the public, there is a test period that's identified in 251.02, and this process essentially explains that that there'll be an evaluation and test period of the sports wagering operation to make sure everything is running as it should and secure as it should. This again mirrors 151 in the way it's set up. Once the test period is done, a certificate is when the certificate of operation would issue. That's described in 03. And the term of it is coterminous with the license, so that if it's a temporary license, as we've talked about before, it follows that process. If it's a full license, it follows that. I should say, follows that timeline, and otherwise it follows the full period timeline. Caitlin, Todd, or Paul, anything to add that I missed?
No, I think that covers it. Sorry, I was looking for the mute button.
Go ahead, Todd.
No, all set. Thank you. Sorry.
So could we just take down the screen? Because I just wanted to have a pretty open conversation with the newer commissioners, and Commissioner O'Brien will no doubt chime in. And I want the legal team to correct me. But there's, as you can see, there's a test period where the commission is given the opportunity to designate someone to do in the physical space of testing. This was done with the opening of the casinos, and the way it was done in the past was that one commissioner was designated by the commission. I can tell you that the commission can't make a decision to designate more than one, because I understand open meeting law could say that that's some kind of a public body. My problem with the designation is that I have the privilege of chairing 4 of you, and I would love for everybody to be able to participate in the testing. And under the statute, I understand that I have the ability to make assignments. And my preference would be able to assign, if this was compliant with the open meeting law, 2 to go to each site to test for the in-person sports books and make sure that they fully complied, because I feel then they can talk to each other and it's a better process. And then everybody gets some chance to participate. I also need clarity about what testing of the online. Is that going to be coming in front of us as a commission, one sweep, and that will be testing something? How do we test that? So that's a big question on the online. This follows what was the test period for the casinos, and Commissioner O'Brien was the tester for Encore. 2 others were testers for the other 2. But it means that an individual commissioner went out, and I remember thinking that was, and it was interesting, but that might be the only paradigm that works. So I wanted to put it out there because of my instinct to allow for maximum participation if we are in fact going to designate a commissioner, or if we want to have 2. So I throw that out to the legal team. Commissioner O'Brien, I don't know if
So,
you want to add.
Well, no, what I was thinking in terms of sheer numbers, I'm more than happy to pull myself out of the mix. I mean, I've had the opportunity to be the tester at a facility. I know that the three newest commissioners, none of them have. You might have 3 physical locations. Obviously, if you were to go to any of them, that wouldn't be violation with having the 2, but I'm happy if it makes the math easier also to simply, step back. However that turns out to be, that might make the math a little easier.
Or,
I think,
if we did the assignment, would that be permissible so that you could talk to each other? I just am wondering if that's an attractive option.
Yeah, I think the concern is not necessarily that there would be a quorum of the commission, but that more than one could be considered a subcommittee that is established, and that it would still be subject to the open meeting law, even if the chair just designates the people.
Assign them to do
Or
tasks.
sign, designate, whatever. But yeah. So anyway, that's the concern. You could just mark it up as a public meeting and allow people to follow you around, I suppose. That's one way to do it.
I'm okay with that. So, Mina?
Yeah, just to add to that, I have the same, I think we're all on the same page in terms of what the concern would be. It's if you weren't deeming it a subcommittee and you were having it as a public meeting, you would effectively be doing a site visit under the open meeting law, which is also permitted. However, what you have to be careful about there is deliberation during it. So it would be appropriate for commissioners to take in information, but when you say, talk to each other, issues that are raised from that test period should come back to a duly noticed meeting. So there may be some logistical things to work out as an open meeting law, but I think, we have the same reaction Todd had.
So the assignment is off the table.
No, I mean, if that's really something that you want to do, we can try to think about ways to do it. But that's the reason it was done the way it was done before.
Commissioners, I'm fine with it if we want to do single, and then we'll pull it out of the hat as to who goes where. If that's okay, so that we'll just make that decision in a public meeting as to the assignment as to place. So that unless you choose it, I just want to make sure everybody recognizes that it could be a day in January or February. So Commissioner Hill, are you okay? I see you nodding. We'll just do something fun like that, right? Commissioner Skinner, are you okay with that? And Commissioner Maynard, are you okay with that? Okay.
Yes.
Okay. And then in terms of the testing for the for us, we are not going to be going to a physical plant. So will that come before us to test the online? How are we envisioning that process?
I can't. Yeah, I don't. That would be something we might have to get back to you to discuss a little further. I mean, I know we kind of have thought it through to the point that there has to be a testing process. How it will actually work, I can't really speak to right now.
Okay, so let's look to see how the reg is written. Because we're going to have a bunch of onlines. We've got ultimately perhaps five retails. It works well to translate 23K to 23N for the retail, but it's a little bit more of a challenge for the online. Did we speak with Sterl? I see that you're on. Have you thoughts?
My understanding in what was done in other jurisdictions is what could be done is the testing could actually take place in Boston. We are going to have our IT team overseeing all of these platforms, and I'm sure Katrina could probably speak to this more, but that the testing and the processes of all these different licensees will have to then be tested in an environment in the IT world, right? So through the web browser or mobile application. I see Katrina's here, so she might be able to
Thank
speak.
you, and I think Kevin has joined us. So Kevin and Katrina, sure, thank you, and chime in as we grow. This might be a really helpful discussion just as we think about this is a significant piece of our business. So Kevin and Katrina, with bodies like ours, how does this testing happen usually?
Yeah, so, and I've asked Joe Carlin to join if he can, to add, he runs our digital and sports betting testing group globally. So probably best you get it from the engineer, not the lawyer. But because it's an adoption of GLI 33, and I see Joe Bunavith has also joined us, who has a technical background and might add to anything that I would say. But because you've adopted GLI 33 and because we don't know who all your operators are yet, but the vast majority of them are operating somewhere in the United States and already subject to GLI 33, and the platform's already been tested to GLI 33. So what really needs to be done is the local deployment. So it's the geolocation, the network security on the local server, it's the integration of the local server, but the system, the fundamental system that they'll be using has been tested repeatedly and ongoing according to the change management program. So Joe Bunavith, do you have anything to add to that?
So the operators are quite used to, obviously, this process in all the other jurisdictions that are live. They will submit their final software headed towards the Massachusetts market once the technical regulations have been approved. And we will test that in lab, verifying that that software is the piece of software that ends up heading toward the market. And we will issue certificates upon approval, which includes all those parameters that Kevin just mentioned. The geolocation, the critical file checks that, we can get real technical here. And then post the MGC's approval of those certifications for those individual operators and suppliers, they'll be, as long as you guys say so, they'll be good to go live.
And I can say that there hasn't been a single market where we have not been able to meet the deadline from a testing perspective, and that includes some very, very aggressive launch dates. In fact, includes some jurisdictions that launched before their rules were even finally approved. So as far as areas of concern, it's not rise towards the top of my list.
No, Chair. Yeah, I see Katrina. Now, if you could translate what you're hearing from our GLI colleagues, how do you imagine it unfolding in front of the Gaming Commission for our final approval?
So very much in line. Thank you, Madam Chair. Very much in line with what they're saying. So there's a lot of prep work that we're going to do once the tech regs have already been approved. Like Kevin Mullally stated, a lot of these software, firmware, et cetera, has already been approved in other jurisdictions. So the core coding, the core firmware, the code, the software, all of those things that we can test in advance, we will do. And we will have all of those certificates and signatures and everything else. So when we're ready to go to launch, there will be that pre-launch phase. Prior to that, we will validate with the operators and the licensees that these are the signatures and the softwares that have been utilized and launched in the jurisdiction. So it's almost like a two-step phase. So there is a lot that we will be doing once the tech regs have been pushed through in anticipation of that pre-launch phase. And again, a lot of this is so digital. It's pretty, this isn't their first rodeo. So we get the benefit of that. And the operators and the licensees will work very quickly and agilely to get us the information that we need to ensure that we're able to launch on time.
So this is really helpful because I think it's informing this regulation that's in front of us now, which is, the sports wagering operations certificate. And I'm just trying to imagine, I think we've got the retail in our minds. It's familiar, at least to two of us, and the other three will catch up very, very quickly on it. But now I'm just trying to imagine Mina and team with the input that you just got. How do we address the online with more specificity, or is it not necessary?
I certainly, welcome others' thoughts on this. My thinking on it, this is sort of what I was getting at with the keep it broad, but not, identify the things you have to do at a broad level, but not get into the weeds so that you don't tie whether it's GLI or Sterl or Katrina's hands as they go do the testing process, especially when we see who the licensees are and what kinds of platforms they have, what issues might be coming up in the industry at that particular moment, et cetera.
Commissioners, do you have thoughts on this at all? I guess I'm pressing a little bit, Mina, because I don't even see category 3 mentioned. But this does encompass it, right? Am I wrong?
Yeah, sorry, no, I was having trouble finding.
So I see above, or probably I see the issue around displaying form, but in terms of our testing,
in the test
operator, but you have a lot about category 1 and category 2, and I just wondered.
Correct. The sports wagering operator captures all of them. The reason that 01 has a little bit more about 1 or 2 is it carries over the 151 issues related to actual physical facility, but that may or may not actually be the bulk of the work. It's just a matter of repeating some of the ones in 151 to make clear that those may need to be updated.
Have you had a chance to review this, and Kevin, this regulation?
Sorry, was that directed at me, Madam Chair?
No, Kevin and Katrina.
I have not seen this particular reg. If we're referring to 235, the occupational, my understanding, and I could be completely incorrect in this, is this was specifically geared towards the category 1, category 2, that the category 3s, since they really don't need an occupational license in its definition, would be handled differently. But am I looking at the wrong thing?
This is 251.
This is 251, Katrina.
Oh, I'm sorry. I apologize. I was looking at the wrong thing. No, I have not seen this as of yet, and neither has Kevin.
Yeah, we actually did see it, and I'm fine with it. It's not something that's used in every jurisdiction, but I think it's a healthy tool. A lot of times it's rolled into the licensing resolution, the things that you're talking about here. And if there are any specific concerns, and most of the time there are not, but there are occasions where there are, you can put in if you use a licensing resolution, you can use conditions of licensure. And I think that same concept could apply to a certificate of operation, and it's alluded to in the regulation that you can apply specific conditions if there are specific operational concerns for a particular deployment or particular piece of technology. So it gives you a lot of flexibility. Let's hope we don't need to use any of those tools, but I think it's pretty straightforward from our perspective.
And Madam Chair, just one clarification. When you said Kevin, I meant Kevin Gavreau, not Kevin Mullally. So I apologize for that.
Oh, that's okay. I appreciate everybody being so available in this way. I really appreciate it. Mina, are you satisfied?
We're certainly satisfied that captures category 3s and that it leaves that flexibility, but Yes, I'll obviously others have comments.
And then this
Yeah,
is
I mean,
strictly procedure, guys, because I understand, Kevin, it was really helpful to understand what other jurisdictions do. But are we envisioning at some point, let's just say we have 15 category 3 online sports wagers, that they will come and there'll be all the evidence of their compliance that with all the testing requirements, and they'll come in front of us and it will be in a public meeting and we will do a check off and an approval. Is that really what we're envisioning for testing for the gaming commission? Because I'm just trying to understand the process that would work. Todd, are you imagining that too?
Yeah, essentially, I think that's exactly right. We'll come before you, say, here's everything. They've submitted this. We've done a test period. We'll go through the whole list, and then you'll say, hopefully, okay, we vote to award the operation certificate. Now you can start operating. So absolutely, that is kind of how I would see it.
Yeah, I agree, Madam Chair. Very similarly with what we did with the land-based side of things. I mean, we had technological components that needed to be approved as well for that. And so we came with a checklist of things. There were our certification letters that were attached, and that was part of the approval process to move forward with being able to open to launch. So we would treat it very similarly.
Except in the retail, there's an individual commissioner that kind of is associated with that in-person check. Okay, I'm happy. This is, sorry to spend a little bit of time, but I am actually thinking not only of the process, I'm thinking of our calendar. So thank you. Thank you very much.
Madam Chair, if I may, Joe Carlin has joined us, and he's very good at providing a brief, high-level overview of what goes on in the testing process. If you're of a mind to listen to that, I think Joe's available. I saw him on screen.
Yeah, he was on. Hi, Joe.
Yes. Hello.
Here you go.
The question is just a high level of the testing and certification process.
Yeah, high level, what needs to happen before launch and what our timeline is, and some of the aggressive timelines that we've worked under in other jurisdictions.
Okay. Yeah, absolutely. First, I'll talk about a complete high level, but know that a lot of this work has already been done with clients that we're handling in other jurisdictions. But first and foremost, we start with a complete architecture review of the system to identify the areas that have critical regulatory relevance, isolate those. First step in any submission is a witness build process where we're watching the checkout of the source code for the product, all steps of the compilation, and creating the files and having a chain of trust over that entire process. And then ensuring that those are the files that are deployed to the test environment. Ultimately, those files in the SHA-1 hash as a digital fingerprint to match those in production are listed on our certification report. From there, we're going to break down all of the elements of the player account management platform. So everything to do with the registration process, age verification, everything to do with responsible gaming, all of the account controls for a user to manage their account like they would a bank account, so to speak. There's some equivalents that you could draw from there. To close that account, what happens if the account goes dormant? Inactivity timers for protection against, again, underage gaming, geolocation, data logging, reporting, all of those aspects that are sort of front end player-facing items. And then we're going to fully evaluate the sportsbook product. So looking at all of the events and markets being like point spread, money line, different types of wagers that are offered, those combinations, all of the exotic wagers where teasers, parlays, and other things can be wagered on, retail and mobile, if those are together. We're doing cross validations within accounts where that exists. We are looking at cross validations between kiosks and point of sale, making sure that that's place at one can be redeemed at the other within various limits, ensuring limits are enforced. We're creating a whole number of events on our own to hit edge cases. We're also, through the testing process, having live feeds integrated and fully testing with real games that are actually occurring in events, NFL, NBA, NHL, MLB, depending on what time of year it is. So that's the end-to-end of what we're testing and certifying. Again, the areas with significant regulatory relevance, having to do with player protection, state protection, accurate accounting, and fairness in all aspects. With our clients, most of which we're very familiar with, the process, we've done a lot of those steps. We're looking at taking the latest version of their platform in, understanding all of the changes, applying the new set of requirements for, in this case, the state of Massachusetts, and ensuring that the product complies and signing off on each one of those points, point by point. Because of our familiarity, because of the base work, the timelines can be accelerated for end-to-end testing, within, potentially as small as a week, depending on ongoing work that we're doing with a client, to, anywhere in the 2 to 3 week range. Max for a brand new client that we've never seen before would be somewhere around 6 weeks. All very dependent on number of issues, responsiveness, availability of environments, and other factors that we work day in and day out with suppliers on to address.
So I know Joe.
This process is the timing. Excuse me, Joe. So sorry. The process. That's why Karen would do some work with GLI, and that's how we got to the. I understand. Wow. As well as some other work. Joe, I didn't mean to.
I'm sorry, was I the only one that had trouble hearing Kathy?
Yeah, Madam Chair, that thing is
No.
happening again with your microphone.
Oh, sorry. Thank you, Commissioner Skinner.
So you might have to
Hi,
repeat what you
please.
just said. Sorry.
Wasn't that interesting? Let's see. Let's try this, guys. And then otherwise,
Madam Chair, just to let you know, sometimes that breakup happens if the audio is picking up background noise from someone else's audio. And I think it was. I heard a little humming from somebody's connection. So that could have been why you cut out.
Katrina, should I keep off for both speaker and microphone the echo canceling? Is that are those the?
That is, the echo canceling is your speaker and microphone. That's the docking station.
Checked for the best audio.
I would use that. Yes.
That's what I have. So maybe there was some disruption. I'll try to stay close to the microphone. Joe.
Yeah, I was gonna know. I know that Joe Carlin has a hard stop like right now, so he's gonna jump off. I will note that every single element that Josie just mentioned is documented in the tech regulations that comes from GLI 33, which is the accepted standard across the industry, frankly, across the world, when it comes to event wagering systems. We go straight from all the front-facing elements, the geolocation, age verification, all that account verification, deposit withdrawal, all the logging, and all the timestamps, data marks, every single thing is checked on that end, as well as on the sports wagering platform, which is where the bets were accepted, all those, the prices, the teams, the event times, the timestamps, every single thing is logged and capable to be recalled and audited. We check all of that, and that is contained within the tech standard as well as GLI 33.
Madam Chair, it's for that reason that Joe just mentioned that I didn't look at this set of regulations with a technology lens. And maybe I took the wrong approach, but I read these regulations as more requiring an IEB presence with respect to the testing. So maybe Director Lilios could speak to that a little bit if I'm just way off base. it's good to know that too, but I didn't, because the technology piece is covered under a different set of regulations. I just assumed this was all from a compliance perspective.
And can I just interrupt briefly? I understand that maybe IAB is involved. I'm looking at this strictly as to what the commission has to do to issue that certificate. And it was just, I very clearly could understand the process from the retail side. I understood that the technology piece would come through GLI. I just wondered what our process was going to be, because we are going to be signing off on these operational certificates, I understand it, in some form or fashion under this reg. And so it just wasn't as clear to me as with respect to the online, what our process was, that's all. Director Lilios, if you want to weigh in on that.
Thank you, Chair. So I think the process for the retail is largely going to mirror the process for the category 3s. There are, as Mina pointed out in the reg, I think there are 3 or 4 subsections that specifically address an in-person environment. But the testing, the certifications, and the review of the internal controls, they are going to mirror one another in both the retail and the digital environment. So it's the picture I have is that for each of the up to 7, the IEB, with the assistance of GLI and our tech team, will be coming to you for approval of the operations certificate, with your designated commissioner having been there for the conditional.
So you're saying that it doesn't apply to the category 3s broadly, just the untethered, Loretta?
No, I think it applies to all.
Yeah, so it's like maybe up to 15 that'll be tested.
Yes, yeah, correct.
Okay, good. All right. No, I think I'm good on this. I understand it now, and I understand the process and the regulation, and I'm imagining it in terms of the timing working out just fine. Commissioners, do you have any questions? Thank you for your patience as I work my way through this regulation. Okay, do I have a motion? I guess, Mina, you do want this voted on today.
Judge Stein, I don't believe Mina was done. He didn't get to section 3, which I want to make sure that the correction is made in that section.
On the duration?
On the duration, yes.
Mina?
Sure. Let me try to address both, and Todd and Caitlin, tell me if I'm wrong. I think this is the first time the commission has seen this one, so I wasn't sure if it was up for a vote today.
It is the first one.
Okay. So I'll defer to Caitlin and Todd on whether it's ready. It was expected to be voted on today or not. With the second, actually, Sterling, I was done. We had it. I think this is where I was saying we went back to testing, but on 3, the upshot is that the certificate would be coterminous with the license. So for a temporary license, it would expire with the temporary license. Otherwise, it would expire. But if there's an issue to talk about, certainly.
Yeah, just if you were sharing it, I just wanted to make sure section 1 had the proper reference of 0.02 rather than 0.03.
Oh, I'm sorry. Thank you. You're right. I had forgotten that. That's right. Carrie caught that this morning and had asked us to pass along. And Sterling, I appreciate the correction. So it's just a cross-reference. Thank you.
Yep. So that'll be fixed. So do we hold on this for public comment, Caitlin, or no? I see weighing
The
in.
commission can vote on this to promulgate by emergency, which would then start the comment period and the promulgation process.
Okay. Any further questions? And thanks again for your help as I navigated that. Do I have a motion? With the one edit, don't forget, that was just made. Thank you, Sterling. Commissioner Hill, are you leaning in?
Yes, for some reason I was having an issue with my mute button. I apologize. So 205 CMR 251. I move that the commission approve the small business impact statement and the draft 205 CMR 251 as included in the commissioner's packet and discussed here today.
Second.
Any edits or questions? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes, 5-0. Thank you.
Madam Chair, I move that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that the staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved, or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Thank you. Okay, any questions? All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Okay. It is 12:09. Does anybody need a quick break before we go on? We have the equipment kiosks, and then of course GLIs. Well, how would you like to proceed, commissioners? I want to check in with you on your.
I need a break.
You need a quick break. Good.
Madam Chair, we didn't get the timed agenda. Just wondering if there's a lunch break contemplated in the day?
Crystal didn't do a time because we were only doing regulations and it was hard to predict. So
yes, it's no
yeah.
problem. I'm just wondering because if we're taking a longer lunch break, then I would opt to forgo the break right now.
Well, unless somebody really needs a break right now, then
I'm right, and I'm just giving my preference is all.
So,
you're calling for preferences, right now,
no,
so I'm just sharing that.
I'm calling. Does anybody just first off, I should ask: do we want a lunch break now, or do we need a quick break now? Commissioner Maynard.
Either way, I need a break.
I understand. Commissioner.
Why don't we take 20 or 30 minutes now and then we can power through without having a,
that seems reasonable to me. We'll do that as long as everybody's all right with that. We will have a lunch break now. It's 12:11. We'll reconvene at 12:40. Okay. Thanks, everyone. And thank you, Mills. Thanks, Mills. We can probably turn down the screen now. There you are. I think we've got everyone now. Okay, so this is reconvening after a short break of Massachusetts Gaming Commission's public meeting. We're holding this virtually, so I'll do the roll call. Commissioner O'Brien.
I am back.
Thank you. Commissioner Hill.
I'm here.
Great. Thank you, Commissioner Skinner.
I'm here.
And Commissioner Maynard.
I'm here, Madam Chair.
Okay, excellent. And this is the reconvening of public meeting number 403. And we are looking at a whole bunch of regs today. And we just completed the operation certificate. Moving on now to sports wagering equipment and the small business impact statement. So, Todd?
Thank you, Madam Chair, Commissioners. So now we're at 4B, 5, 6, and 7 on the agenda. These 3 items are all related. We'll present for your review drafts of the regulations governing the technology standards that sports wagering equipment will be required to meet, as well as the process under which such equipment will become certified and approved for use, as well as the process under which modifications may be made. Let me just introduce everyone who is joining us. First, you can see Mike Robbins, who is the technical compliance specialist from GLI, has joined us, and he will present a bulk of the drafts and walk us through the materials. You can see also, of course, that Kevin Mullally is alongside, as well as Joe Bunaveth, who are here as well. And I'm not sure whether there are other members of GLI joining us, but that is a significant portion of the brain trust there. We're also, of course, joined by our very own Katrina Jagrup Gomes. So we will all endeavor to walk through the drafts before you. I'd like to just offer a brief preview of coming attractions, if I may, as the drafts you're about to look at contain a great deal of substantive material. We'll begin with 205 CMR 243.01. In this draft, the proposed language would adopt GLI 33 in that standard, which has been referenced earlier, which is the standard that applies to event wagering systems. And the proposal is to adopt that by reference. And I thought I would just mention, by way of brief background, that the format in which this draft regulation appears is consistent with the manner in which the Commission has adopted a series of other GLI standards on the gaming side of the ledger. And that is to say that the GLI standard is adopted by reference as the baseline, and then the regulator, meaning us, of course, amends the standards in certain areas to ensure that the state's legal requirements are satisfied, that Chapter 23N is captured appropriately, and that we answer other certain questions that are left open in the standard itself for the regulator to answer. And Mike will walk through all of those areas. We'll then pivot into 243.02 and 143.07, and I can certainly refresh everyone's memory when we get to those, but just by way of background, those are the regulations that will govern the standards that kiosks will have to meet. The Commission has already adopted GLI 20, which applies to kiosks generally. This standard has been in place for all the kiosks used in the gaming operations already. The proposal before you is that the version of that standard that is employed be updated from the 2011 version to the 2019 version. And Michael explained the differences between the two a little bit, but it's important to note that the amendments being proposed would make this section applicable to sports wagering operations as well. And then we'll take a look at the 243.02, which is the companion to that. And you'll see there that there's no substantive language in this draft, but instead it simply cross-references and directs the reader to 143.07, which is where GLI 20 is adopted by reference. The purpose of this 243.02 is just to ensure that a sports wagering reader of the regulation knows that they have to look into the gaming regulations to find the standards that apply to kiosks. And hopefully we can explain this a little more clearly as we walk through that draft. And then finally, we'll look at a draft of 205 CMR 244, which in a nutshell governs how sports wagering equipment will be actually tested, the process for approval for use, and importantly, how the change management program will work. So those are the series of draft regulations that we are going to walk through. And if there are no questions, I'll turn the program here over to Mike Robbins, who can walk us through the drafts and help to address any questions we might have. Mike, welcome.
Thanks. Basically, just to kind of speak about GLI 33 from a high level, GLI 33 was a standard that was developed to handle all forms of event wagering. So we use the term event wagering because we view sports wagering as a type of event, but it could be extrapolated to different types of wagering should a gaming commission or adopter wish to stretch it to that. That being said, GLI 33 has been adopted in about 33 jurisdictions around the world, and that includes the majority of sports wagering markets heavily rely on GLI 33 as a technical basis of standards for this type of equipment and system and the like. When it comes to the brick and mortar retail type of sports wagering, such as the Cat 1, Cat 2, there's also the addition of GLI 20, which is the kiosk standard we'll be talking about shortly. I'm gonna basically step through, and if I can be given the ability, let's see if I can share my screen. Yeah, screen. What I did here was just to make sure everyone can see my screen, correct?
Yes.
All right, what I did here is I basically took the proposed regulations on the right and a copy of GLI 33 on the left, and kind of illustrated how these edits are reflected in GLI 33 when it's made, when it's viewed with the lens for Massachusetts purpose. Now, a lot of like these first couple of sections are typical boilerplate that has been utilized in the 143 regulation updates to other GLI standards. So I'm just going to scroll right through this. This chapter is just basically an introduction, what the purpose of the regulations are, and just talking about like, okay, this is going to be used as a part of the framework. And then we get to chapter 2, which is more or less where a lot of the system platform elements happen. So this is your wagering engine. This is your sports book, where this is also where your player account management exists, or sports wagering account management would exist.
Hey, Mike, I'm going to interrupt you just real fast
Sure.
just for the record, and so the commissioners can note that if you do need a copy of GLI 33, we can send one to you, and it's also available on gaminglabs.com. Download it without any friction. You can download it straight from the website. So this is how we publish these for public record. All the standards, including GLI 20 and GLI 33, you can find right underneath the standards tab on gaminglabs.com, on our website. So if you do need to actually take a look at the individual standard.
GLI 33 is part of our packet too.
Got it.
Yeah, thanks, Joe. So all of the GLI standards, GLI 33, GLI 20, and when we get to it, the GLI CMP are available on our website. But anyway,
Mike, just sorry to keep interrupting. Just one further contextual note that I think is important. is that these are developed and using a process that very much mirrors a state rulemaking process. And GLI makes no money from them. Anybody can test to the standard. It's actually a fairly significant expense that Mike Robbins and others administer. But when we come up with a new standard or come up with a new version, it's circulated to regulators globally for comments. It's our intent to publish the standard as a global consensus on how regulators feel about technical issues. Whoever comments forms a working group. The standard is then put out to the industry for comment. That working group goes through the industry's comments, and eventually we arrive at a final version. So very much it's like your state rulemaking process.
Yep.
Thank you.
So anyway, just to scroll through here, what I basically did just to illustrate how this affects it. So you have this section here says, add the following as 2.1, and it's reflected in this document right here. So your first section, you talk about your system clock, your control program. This is the verification that we were discussing earlier. Making sure your control files are correct. Your wagering management to enable and disable different wagering types, different betting markets or wager categories, and of course your wagering devices. And we use that term within GLI 33 to cover both sports wagering kiosks as well as mobile devices, and as well as ticket writer stations, which would be your over-the-counter points of sale. And moving along, we have your player account management. There's a reference made to the 205 CMR. Those regulations, draft regs, have been submitted for review. So just scrolling down. Here it's just basically it's talking about your player registration piece, but a lot of this stuff is going to be elaborated within the sports wagering account CMR section. But here's some more technical requirements related to this. One of the things to point out here is to serve the purposes of the Massachusetts statutes, we updated 2.5.6 basically to alter the wording because 23N has restricted the use of credit card transactions. So the verbiage here has been updated to reflect this. Just to give an example, we have a section regarding what needs to be in your player account statements. We talk about player loyalty. And here's the section I kind of wanted to point to here. Is location requirements. So one of the things that we've seen in all sports wagering markets in North America is, or in the US particularly, is a requirement for some sort of location detection service. And that's basically to ensure that wagers are being placed within the state. So you see here removal where required by the regulatory body. This verbiage is in the standard because not every jurisdiction, who's adopted 33 is from the US. So some of them don't have this level of location verification requirements. So that's why it says where required by the regulatory body. But moving along to 2.7.4, which is really where we talk about the category 3 type of online sports wagering. We added in the specification from 23N that all wagers need to be taking place within the Commonwealth. We also updated A to kind of talk a little bit more about increasing periods of location check when the player's located within 1 mile of the state border, for this purpose. And And we also added a requirement at the end, and this ties back into our testing requirements that we'll be discussing when we talk about 244, is that this location detection service needs to be tested by an independent test lab. And this includes applicable field testing. And what that really entails is well, the most common experience is independent test labs will send people out to the border and drive across the border and do a series of tests where they either set up the bet on one side of the border, then jump to the border and see if it goes through, or other such activities, or trying to basically make sure that you can only place wagers within the state. That being said, also that we've heard of regulators and internal organizations also do similar testing. This kind of goes back to that operations testing period that you were mentioning earlier. This would be a part of that, where the site is live for the purposes of testing, but it's not live for the purposes of fully operational. So one thing I wanted to bring up here too is we talk about wager record information, which it aligns a lot with what is required by the 23N. And one thing we added here was we updated item O to kind of reflect this use of this collection of additional player data when a player is placing a wager which exceeds, and we use the $10,000 or wins a wager exceeding 600 and is 300 times the amount wagered. And basically we put that in there to kind of these are like your values that you'll see for to meeting the bank, the BSA, the anti-money laundering, and as well as the IRS W2G lockup or W2G requirements. So then moving along, we actually parrot similar information again later on. We were talking about large wins, large wagers, large financial transactions. Most of these are to assess, to apply to the federal regulations already in place for this purpose. We add this section in to tie back to the statute talking about timely filing the reports. And here's some additional reports. Now, 2.3.1, this is where we're talking about your wagering device. And as I mentioned earlier, this covers both your Cat 1, Cat 2, and then for Cat 3, the remote wagering device. This is the software requirements related to it. This is a section where we're talking about self-service wagering devices, or we call them, sports wagering kiosks for the purposes of these regulations. And we added in a reference to 205 CMR 14307, which we'll be updating to reflect the latest version of GLI 20. And just a real quick talk about that update. The main purpose of that update to GLI 20 was to kind of build support for kiosks to be used for sports wagering, and also extend any sort of kiosk that could be used in other forms of gambling. As it was originally written, it was heavily focused on just ticket redemption. And while the new version, the 2.0 version, does still retain that functionality and support, we wanted to expand that support such that it could be utilized for sports wagering or player account management, or anything else related to gambling that isn't necessarily done on a gaming device or a mobile device.
Mike, can I ask that question? So the technology right now, the kiosks they will be used for those multiple purposes that we'll see put into.
So for the most part, the kiosks we've been seeing are a little more focused. That being said, we've definitely seen concepts that are multi-purpose. So we wrote the standard in such a way we didn't want to be a hindrance to new innovations in technology. So we wrote it in a way that should it be able to support this functionality, we didn't want to ice it out through the standard. So we have encountered kiosks that might have the functionality to handle acceptance of player account transactions and to either deposit or withdraw funds, as well as handle sports wagering, ticket issuance, and redemption. But we've also seen separation where you might have a kiosk that it's only going to accept money and spit out a sports wagering ticket, or it'll cash out that sports wagering ticket and give you a voucher, and you got to take that sports wagering voucher to the cage to be cashed. We've seen, we wrote the standards in a way to accommodate all scenarios, or at least as many scenarios we could think of at the time.
Got it. Thank you.
Yep. So chapter 4, this is where it actually talks about the action related to sports wagering, where the functionality of the placement of wagers, the display of information related to odds, and also talks about functionalities where we've seen systems that might support it, but it hasn't necessarily been too popular yet. But once again, we wanted to write a standard in such a way to be open to newer technology. So like you might have a player resource feature that offers you some sort of tip. And we haven't seen this implemented, but we have heard about it through various channels. Another thing too that we wanted to account for is an acceptance of changes in wagers. And this is because when you're at, these odds are updated continuously. So they're not, it's not like it's updated once every 10 minutes or whatnot. Like it'll be updated, it can be updated in seconds. So there might be a chance where you're placing a wager and you have really good odds, but something happened and the odds changed. And if the odds are worse, then you'll be like, if the odds are worse, and you'll end up with like less of a payout if your wager wins, the site or the kiosk will be like, hey, these odds have changed. Do you still want to proceed? If you win, you're going to get less than what you were originally interested in. And this is let me reiterate, this is before you commit this wager. So once you place the wager, it's fixed. It's going to be fixed, and whatever your odds are at the time of that commitment is it for the purposes of fixed odds wagering. Now, this automatic acceptance of changes would be if the odds got better. So say my payout on a wager when I clicked, hey, I want to place this wager was $1,000, but the odds changed within those few seconds, and I actually, if I won, I'd get $10,000. Well, it's going to let you, it's going to place the wager and be like, hey, guess what? These odds changed in the past 2 seconds, and if you win, you're going to get more. And then there's a wager record, and the wager record is synonymous with a sports wagering ticket or a bet slip, or just basically what is the wager that the player sees. So we use the term wager record to cover both the physical sports wagering ticket, which could come out of a kiosk, as well as a virtual sports wagering ticket or bet slip or whatever you want to call it, that will appear if you place a wager using a mobile device or a computer. So yeah, the next sections talk about the wagering period, which is the time you can place wagers, free play mode, your payment and redemption of winning sports wagers, and then you got section 4.5. Now, 4.5 talks about a concept called virtual event wagering. This is not to be confused with esports, where in esports you're wagering on an event played by athletes who are playing video games against one another. This is more a simulation of a sporting event as you would see it, and on so for instance, take the NFL. Like, instead of wagering on a live football game, you're wagering on a simulation of a football game. Bonavith, can you?
Yeah, so I'll take a half a step back first. Virtual event wagering will have to be an event approved for the catalog. First, it is a simulated event. Typically, a lot of the it hasn't really gained much traction in the United States, frankly, but it's actually quite bet on worldwide, especially in virtual soccer and horse racing. And it's an actual RNG that delivers an experience, and the content looks like an actual horse race or soccer event. It's frankly, the technology is kind of amazing now, and you almost cannot tell that is an actual computer simulated event. But if the commission were to go forward and approve such a offering for the catalog, this part of the standard would be applicable to make sure that virtual event is tested according, to be compliant. How's that, Mike?
Yep.
Yeah.
That's good. And the other thing too, just to bring up, and when we do get to the, I think it's 245 or 246, which does talk about the rules related to sports wagering. Those rules that have been drafted and submitted for commission review does go into the methodology of approval of events, and it does mention virtual event wagering virtual sports wagering specifically, just to tie back to this. So this would have to be an approved event, and it actually did catch on in a couple places during the pandemic. Not that I'm saying we're going to end up back there, but we've also seen a lot of interesting implementations. So say, for instance, you take the stats of a team from, say you take the stats of the Patriots from 2 years ago, and you're like, okay, well, how would they fare in a game against the stats of the Patriots of 1 year ago? And you kind of set up this this virtual event using those statistics, and there's gonna be some weights and some RNG calls to handle the randomness aspects. This would basically this would fall under the whole virtual event section. So moving on here, we also have the external wagering systems section. Now, this isn't as widely used. However, with things like esports and basically niche game game type wagering operators, this might be a situation where you're going to have this kind of talks about the interoperability between that guest system, that host system, and the guest system. So say, for instance, there was an esports wagering provider, and they have their own wagering engine, and they tie into your operator's platform. This discusses like how those wagers are handled, the communications between the two system components. And this wraps up that chapter. Now, Appendix A, this is when we start talking about internal controls, and this is the intention of this chapter really is to provide a framework of internal controls that are common throughout the industry, and that basically any sort of additional internal controls, it would be up to the regulatory agency to adopt alongside of or in lieu of this section. And for the purposes of Massachusetts, we've submitted our recommendations to 138 and potentially 238 to kind of tie into this chapter, as well as establish controls that are going to be specific for the needs of Massachusetts. But what I am going to talk about here is this independent audit section. So basically, it talks about the ability that each operator is going to have their procedures and practices, their internal controls audited at least once every 2 years and submitted to the commission. The thing to bring up here is that these internal audits can be conducted directly by the commission, or it could be a third-party auditor, including independent test labs or any sort of other auditor. However, it does give the commission the ability to allow for independent department within that organization to handle the internal audits. So what you'll see in a lot of these companies is you'll have an internal audit department, and they're completely independent of any sort of other operations of the sports wagering environment, and they'll perform these audits and provide feedback to the regulatory body. That being said, it is up for commission approval, full discretion of the commission. And basically, I pointed out G here because what we've, and this more applies to category 3 than anyone, but you might have because you have an operator who's running in many states, they might have recently done this audit. So they might leverage those results previously, or say if like GLI performed an audit previously for a jurisdiction, and the controls are the same, we will leverage those previous results. But of course, this doesn't include any sort of results unique to Massachusetts. So auditing procedures for, say, a sports wagering facility, probably you're not going to be able to audit much in lines of what's happening in the actual facility, but you might be able to audit things that are happening more at the back end level. And so what we added at A21 is a reference saying that the internal controls need to meet this appendix A, as well as 205 CMR 38, which again we've provided drafts, and I know it's on schedule to be reviewed in the near future. So this section kind of talks about just like the internal controls. It establishes some baseline of restricted or prohibited players, some more player account controls, including examples of what you'd see in your terms and conditions and privacy policy, which will be once again addressed more when we get to the sports wagering accounts chapter. Same with financial transactions, limits, exclusions, inactive accounts. Talk about operator reserves, protection of player funds, taxation, player dispute, player protection, and wagering rules. So wagering rules, they're also known as house rules. Usually within regulation, I would recommend calling them house wagering rules when interfacing with GLI 33, just to alleviate the confusion. Also, someone might not understand what house rules means per se. What is the house? But they might see wagering rules like, oh, okay, that's wagering rules. That's rules related to wagering. So here's a lot of rules explaining what's going on. Section on promotions and bonusing, bonuses, as well as rules related to contests and tournaments. We have sections for talking about the procedures for setting the odds and the suspending wagering on markets or events, and that's going to be tied heavily to the regulations for when these might occur. Be it it's discovered like an event is something's going wrong. Either the event it was requested that like to suspend all wagering on the event because there's an investigation, or it could be even related to, oh, it's a rain delay and we don't know what's happening next. So these are basically things that are going to be outlined by your operators. And A7 talks about your wagering venue, your sports wagering facility, or sports wagering area. And this talks about any sort of verification audit. So this would be your on-premises audit that the commission or the IEB would perform, or whoever would perform. And just sections on wagering procedures. And one of the updates here for surveillance and recording, it got changed from 90 days to 1 year, and that's because of the statute. Because the statute basically said that surveillance needs to be maintained for a period of 1 year. So once again, talking about what we were talking about earlier about geolocation, we removed that we're required by the regulatory body because that is going to be something necessary for Massachusetts to make sure that the requirements to ensure that wagers are taking place in the state occur. And now we get to our independent audit or operational audit, our Appendix B, which is our system security, technical security controls. And we added here requirements talking about the independent audit. And we mentioned the 90 days. This is a common industry usage. It's usually within 90 days of commencing operations and then annual audit. And this consists of vulnerability testing, penetration testing, firewall review, assessment of information security or cloud services, and any sort of additional service providers utilized by the operator. And we also talk about what it takes who performs these types of these audits. So we give a little background explaining the qualifications, as well as what needs to be included in the report, as well as mentioning both the leveraging of previous results. Once again, you're going to see a lot of these systems are in many states. So a lot of these audits have already been done very recently. So this would include leveraging such results.
If I can chime in a little bit here, Mike, this aligns closely with the work that the Regulators Network Security Task Force is doing, that Dan Hartman, the director in Colorado, is leading, and that Katrina and her staff have been involved in, along with regulators from almost every other U.S. jurisdiction. And I know they're opening it up to, in the process of opening that up to international jurisdictions. And it goes to the concept that these systems are deployed globally, but regulated locally. And you'll notice throughout Mike's presentation, he's very good at paying meticulous attention to language and what things mean. And one of the values we brought to this process is to try to bring some consistency so that regulators in various jurisdictions are at least at a bare minimum calling things by the same names and using the same terminology. And network security is something that, unlike regulation of land-based casino in the past, that really didn't require terribly high levels of collaboration between regulators, except possibly in the area of investigations. This is going to require a lot more of that, because regulators, at least at the current time, have limited resources in this area. The resources that are necessary to do it properly are highly specialized, very expensive, and need a lot of training to maintain. And so more collaboration is going to be needed to make it efficient, while still maintaining a high level of effectiveness. And so that's what a lot of this goes to.
Yep. So just kind of move on here. We talk about system operations and security, and we update the section on physical locations of servers. And this is basically to specify that it's up to the operator to provide the commission with information on the locations of all servers and equipment used for sports wagering, as well as mentioning that in particular, the primary server utilized for the acceptance of sports wagers need to be within secure locations in the Commonwealth. And this requirement is basically written to cover the Wire Act, because the Wire Act is and the various interpretations of the Wire Act have all had in common the fact that the server used to accept the sports wagers need to be in that state, as well as the player. So for the purposes of a sports wagering system, we've seen what is commonly referred to as a hub and spoke model, where you'll have a central server somewhere, within the US, for instance, and it will have your player account management. It will have your odds feeds. It will have a lot of this information stored. However, when you're making that wager, your point of sale, that server that accepts your wager needs to be within the individual jurisdiction. Now, I always add in the unless otherwise approved by the commission, because the Wire Act is a tricky thing, and there might come another interpretation down the line, or even a complete removal of that interpretation of the Wire Act completely, stating that, oh yeah, the wager server could be in other states. And that might be a situation where, leave it to the commission to make that discretion of, okay, we're willing to go with this new opinion, or maybe it's up to the commission to go, well, let's stay on the safe side. We still require that server to be located within Massachusetts. So moving on, there's a lot more security requirements here, and I wish I knew more about cybersecurity, but I only know what's written. We definitely have our team, our bulletproof branch, go into in-depth conversations on cybersecurity if the commission wishes to hear that. But we'll talk about the system security and a lot of these requirements and communications, but I do want to bring up an important requirement here. And we were talking about communications within wagering venues. And I bring this up because there might be a case where within a casino or within a gaming establishment or other sports wagering facility, there might be a Wi-Fi network, and the requirement here is basically say, okay, this network needs to be segregated from the network that's being utilized for the sports wagering system. So your Wi-Fi is not going to be on the same network as the kiosks, basically. So another minor change, just to jump through here, is we're talking about.
Just 1 second, Madam Chair, Did you have a question?
I kind of lost that point a little bit, Katrina. I'm sorry.
No, that's okay. The one about the Wi-Fi with the guest network.
Yeah.
So it's a normal industry practice to segregate your guest access. So if you remember when we had guest Wi-Fi at the Gaming Commission on our floor, that was supported by EOTS. It said guest, and you didn't have access to any of the domains or any of the servers or the applications or anything else like that. And that's because it was segregated away from all of the core systems. So just, simply explained, it's to ensure that the guest network doesn't traverse traffic that has their core systems sitting on it. So there's no sort of implication or risk. It's to completely keep it separated from the organizational systems.
And that was a change that was added to,
That was language. Mike, can you go back to that section right there?
I wondered, I wondered why, is that Massachusetts or is, that would be
No, the
universal?
GLI standards, they modified the language in GLI 33 to reflect that.
Okay.
So that was updated. That WLAN was a little bit more towards, like Mike was saying, hub and spoke methods. This really, really updates it for technological standards today.
Yeah, the whole wireless, the whole purposes of this particular section is more focused on cases where you have where a jurisdiction might only allow for wagering within a particular gaming facility. We've seen this on tribal lands and in other states such as South Dakota and Mississippi. So we just modified that section to include the additional provisions for any sort of Wi-Fi network not interacting with the private network utilized for communication between kiosks or points of sale.
Thank you.
And then just one last section here, one last modification we made to GLI 33 for purposes. And we'll get to change management when we get to the next section, or the next 244 is talking about cloud services. So basically, and we've seen this in the majority of existing sports wagering jurisdictions, that the commission can approve the use of the cloud for hosting backup data or data that's unrelated to the initial placement of wagers. Once again, the whole Wire Act thing that I was discussing about the wagering server needing to be located within the state. This talks about the backups, the systems that are used to maintain backup copies or unrelated data. Once again, this ties into the operators submitting a request for this to the Gaming Commission and the Gaming Commission approving it. And then finally, there's a whole section full of there's a glossary here, and yeah, that is GLI 33 in a nutshell.
I guess I had one question. We have GLI 33 in our packet, but it doesn't reflect these red lines. So have the red lines been fully adopted by GLI now? That's what, I mean, outside of the Massachusetts ones, the ones that are not Massachusetts related, I wondered if that's, you've finished your process.
So this document that I was showing on the left is just illustrating how 243 is applied into GLI 33. So all the modifications that were made in the document on the left are based on the document on the right's modifications. So it's really just an illustrative mechanism for the purposes of this conversation.
So the document that I have in front of me in our packet, that's GLI 33, it doesn't reflect the red line.
That is the version that is posted on our website.
That's right. So, and okay.
Right, so the document on the right, which is our actual proposed technical regs and standards, that's where all of the modifications from the left is being reflected for us.
Correct.
Mike was just trying to show you generally how the mass specific edits were illustrated in the GLI 33 standards as is.
Yeah, that's why I paused on that one because it seemed more universal, but it's still really coming through message through us, right, Gina? Okay,
yes,
that's helpful. Yeah.
This might be a good point to address any additional questions.
I have a question, and if we're getting to this some other time, just tell me and I can table it. But while you guys are on here, the idea of the one step away credit card use, putting a credit card charge on a Venmo or a PayPal, how does that play into some of the standards we've talked about and making sure credit cards aren't being used?
Is Joe Carlin on this call or no?
He is not.
Okay.
No, Joe had to leave.
Okay.
So do we table it?
I would table it. Yes. I'm guessing, and number one, I'm not a lawyer. Number two, I'm not a test engineer. Just to preface this, that there is responsibility on the payment service provider to flag certain types of transactions, because this isn't, you're not the first state to prohibit credit card transactions. Iowa is another state who prohibits transactions for funding player accounts, as well as South Dakota, probably others, but those two immediately come to mind. That, but yeah, we could definitely table this conversation to explain a bit further.
Great, thank you.
So this is, right now, you've walked us through this, Mike, and very, very helpful. And it actually really forced us to become, even better acquainted with GLI 33. In terms of our process today, Todd, and I know there may be some further discussion, but I just wanted to see, Todd, what is there?
Yeah. Hey, Mike, if you wouldn't mind, can you just take this document down for a moment so we can see each other? Thank you. This draft regulation obviously works in conjunction with the two that will follow. This is the first time you have seen this draft. It is heady stuff for sure. If you feel like you're prepared to move it ahead, that would certainly be appropriate. If there are parts of it that would be helpful to digest a little bit further, we can, of course, do that as well. But this is the just kind of the draft proposal.
Is the only question outstanding how we validate that the system blocks credit card transactions? Yeah. So.
Well, correct me if I'm wrong.
I haven't seen the language that, unless I'm missing something, the language that Mike went through. The red line. I was reading language I hadn't today in real time that I hadn't seen.
Oh, well, let me try to explain that if it wasn't clear, because I did get this question once before. The language you looked at that Mike overlaid into GLI 33 is the exact same language that's in the draft regulation that you have seen. It just says, as you'll see, hey, delete this section and replace it with this. And he's just showing you what it would look like if you read the whole thing together. The other way to do it would be to have the GLI standard on one side and the reg on the other. And as you're going through it, whether you're a gaming operator, a sports wagering operator, I should say, vendor, or commission staff, is just to look at the two documents together side by side and check to see whether there have been any Massachusetts amendments to the GLI standard. But yeah, so the version that Mike went through with the edits in the document will not be in the regulations. And that's why it's important to look at the actual regulation itself. Does that,
I think the exercise he did, it was very helpful for me to see. I don't know if anybody else struggled with it. The language is, familiar. For instance, there are a few I just said, oh yeah, I saw that in delete. But it was really helpful. So if we're looking at the reg that you want us to turn to is 243.01, right, Todd?
Well, that's what we just looked at.
Right. And so all the delete sections are all in
the right side. I think the challenge was when Mike was going through the GLI 33 document that he marked up, Unfortunately, he didn't scroll at the same time on the right side to show you where the respective tech reg really address that. And I think that's what might have been confusing.
And I was trying to do that in real time and.
Right, so I think you expected the dual scrolling, and I think that's, Mike, where they might have gotten a little bit lost. So everything on the left is reflected on the right with either a delete with a new language or an edit with new language.
Yeah. And I feel like I kept up with it. Commissioners, are you all comfortable with it? And the only outstanding question would be of the credit card? Or do you want to spend more time with it? Commissioner Hill? Or Commissioner Skinner?
So, Madam Chair, I'm comfortable with it as presented, but I've had the benefit as the commissioner assigned to technology to review these previously. I would say that was before we had the benefit of the GLI training. And by the way, Kevin, Gabe and Matt, they did a fantastic job. But, one of the things I'm wondering is whether the piece on virtual event wagering should be included in the regulation as a deletion. So when I read these standards, I didn't have the benefit of, again, understanding what a virtual event was. So I just have a better context of the standards. And again, I mean, I don't know what other aspects of event wagering are included here that should be taken out because it's not relevant to Massachusetts. Again, like the virtual event wagering piece. So
I think Mike was reserving that for us, right? It wasn't.
Yeah, so Commissioner Skinner and all, the reason I didn't propose that it be removed altogether, and as Mike certainly mentioned and alluded to, is the definition of sports event or sporting event in Chapter 23N does afford the Commission some discretion to decide what types of events will be allowed and not allowed. And as described, that is something that certainly the Commission may elect to allow at some juncture, maybe not right from the outset. I think, and correct me if I'm wrong, Mike and all, by virtue of its inclusion in GLI 33, it doesn't authorize the activity. It just means that if the activity is authorized, these are the standards that will apply. Correct. And that's why I thought it made sense to keep it in, but I take your point, Commissioner Skinner.
And I understand that. I just wonder if we should be a bit more intentional in what we choose to include, than we are right now with, the reserved sections.
As I mentioned earlier, the purposes of these standards are to open up for any or all possibility, but in the end of the day, it is completely under the discretion of the Gaming Commission of whatever jurisdiction who's utilizing GLI 33 or approving any sort of standards. So, there's some section here talking about, virtual events. The reason why we kind of separate it out and create a section for it is there's a lot of requirements involved in it. If you are now having a virtual event, there's software involved with generating and controlling this event. And that's the only reason why we separate it out. As you guys will see in coming weeks, and this is already in the document that we have submitted for review. We talk about the approval of different types of events, esports events, collegiate events, things that aren't basically any events that aren't prohibited per statute, and we do provide full discretion to the Gaming Commission to approve said events.
Yeah, so first and foremost, like I spoke, that's why I interluded on the virtual part earlier. First and foremost, the commission has the approval process of what types of events and types of wagers that can be offered by the operators. That's first and foremost. Say there was a global event that shut down all sports. Imagine that could possibly happen. I can't. No. And the operators were like, hey, you know, all sports are shut down. We have no content, but we have this engine that runs off a regulated compliant RNG of virtual events. We would like to offer that. So if an MGC says, okay, we'd like to approve it, but wait a minute, now there's no tech standard for it because it got removed.
The other benefit, I think, Commissioner Skinner, is that as you consider whether to allow this, at least you have defined parameters about how it's going to be regulated if you should approve it.
Yeah. So the first and foremost process is the submittal and approval by the commission of what events are offered. That is the outstanding.
And if I may add, Commissioner Skinner, Commissioners, and Madam Chair, you know, drafting these tech regs were a little bit challenging because technology changes on a dime, and there's always new things. There's always this new thing that's coming out. So one of the things in our conversations with GLI was to try to keep the language not as open as possible, but to be reflective should any technological or any needs change. In the example of COVID, when COVID happened, everything got shut down on the land-based side because of the physical contact. There may be an opportunity for a virtual event to substitute for a physical event. And so this lends that language to be able to be utilized. But again, entirely up to the commission, entirely up to the people.
1 minute, I just want to pause because this is on our agenda. I think, and it reflects, I think, as Mike just pointed out, everything that is prohibited by statute. It allows us to consider down the road, and I would argue that probably we would mark up, that would be a discussion for under an agenda item, because I think we'd want to learn more about why we might want to prohibit something, and to your point, perhaps virtual, Commissioner Skinner, but I don't know if we would be in a position to make that kind of a determination today anyway under the agenda without knowing more. You know, for instance, you know, we don't know what we're going to get for applications, right? And the products that might be offered. That's just my inclination, Commissioner Skinner, to keep it wide open now. And then we're going to have on our agenda the items that we are going to determine that folks can bet on. And it's my understanding that we might go wide with that, but we might start narrow on it. And so we might not be prepared for virtual then, but today might not be the right time to eliminate any option. But I'm deferring to my fellow commissioners on that. On that point.
If I could say one thing, the idea that the edits that were made in this document were not meant to close doors, except where the statute had already closed that door. So for instance, there was that section I mentioned where it talked about credit card transactions. We made the modifications to that because 23N explicitly says no credit card transactions. That's statute, and that's going to require a whole law to change. So the other section that talks about personally identifiable information, also a statutory requirement. But you know, once again, something like virtual events or, you know, prohibition of any sort of prohibition, kind of, you know, that's kind of where we leave it on a regulatory decision on a case by case, and not so much trying to close the door shut right away.
Commissioners, do you have comments? Commissioner Skinner, you raised a very, very fair point. How are you feeling about it now?
Yeah, no, all the responses make perfect sense. I was drawn to the virtual event wagering because of the statement that it's not offered anywhere else in the United States. And
that's not entirely true, actually. So New Jersey, and if I'm not mistaken, Pennsylvania also offer it. I know for a fact New Jersey does. And other states, including Nevada, allow it.
Okay. You know, and my concern was just, you know, more along the lines of, you know, Massachusetts being the first jurisdiction. So I got a little, you know, anxiety around that.
Well, and I think it's fair. I think I don't want you to be anxious. because you're going to have an opportunity to talk about it down the road when we have to make our determination. So just put it in the parking lot. Maybe your anxiety will go away more as you learn more, but bring it back to that discussion. I think we're going to have, that's going to be a very critical discussion with respect to our offerings. It will probably involve another long meeting.
Yeah, and down the road, say like even if no one requests virtual sports for like 5 years, if 5 years down the line, some operator's like, you know what, I'm going to offer virtual sports, or I want to offer virtual sports, and they make that request. You guys have questions, feel free to reach out. We'll definitely do our thing.
Well, I like Gina's observation that perhaps during the pandemic, and let's not hope for one of those again, that could have been something that was an offering that people would have enjoyed in its computer generated imagery. So,
and I will add the heavy regulated market out of the UK, which is considered the gold standard for iGaming, has had the allowance of virtual events for, I almost say almost a decade. They're taking those bets right now as we talk, in a heavy regulated market there. So.
Well, anyway, I think we put in the parking lot or pin it, whatever phrase you like best, Commissioner Skinner, and we'll revisit that and the other categories. That be an exciting discussion. Okay, I had the chance to kind of go back where I was able to say, oh yes, I see the language now, and it's familiar to me. I don't know if everybody else has been able to navigate the discussion. Would you be willing to move on this today, commissioners? In light of, I think we've got one question outstanding about the credit card, but I think it's certain right now that it meets everything we need, right?
Yeah, Madam Chair, if I may, I think I can address that. I'm not an engineer, but I do review test scripts on occasion. And so what practically and functionally what happens after these standards are adopted is they'll take the standard and all the other requirements for Massachusetts, and they'll determine, has this product been submitted before? And have we conducted a test against that version of the product that is being submitted for Massachusetts, or is the code identical, that we can use those prior test results to certify that particular requirement for Massachusetts, very, very similar to the way we do it on the land-based side. And so because there is a prohibition against credit cards, each platform will be analyzed to verify that it has the capability to do that it is turned on, and that the implementation that is deployed for Massachusetts has that functionality enabled. And then periodically, your team or our team, depending on how you decide to set it up, during your periodic audits of the systems, will again validate that functionality is continuing to work properly.
Is that helpful? Commissioners? Commissioner O'Brien?
Just to follow up, I know I asked you this, casually when I met you. The episodes in other jurisdictions recently where the vendors were erroneously allowing the credit card charges through, were those the one step away, or were those actual credit card charges? Can you see how that
able to find
these had the checks and balances in there? So how did that happen?
Yeah, I wasn't able to find anything in Tennessee other than there was one operator that I believe was running some transactions through their payday loan company.
There were 2 jurisdictions, I believe, that had it, and it was, and I think 2 different operators.
Yeah, I looked to the news articles and I asked our team, and no one had heard that. So if you could forward those articles to me, I can chase down the answer.
Mm-hmm. And so how did the going to the loan get by?
It was outside the system. I think it was in the retail location. Does anybody know the details about that?
I do not.
Yeah.
I can't say I do.
Yeah.
Yeah, if somebody can just circle back to me on that one, I'd appreciate it. And then my question really from here is to our ITP people and Commissioner Skinner, who've been involved in this, really is relying heavily on their comfort level with the status of these today in terms of whether I'm willing to vote.
So Katrina had to jump off because she's conducting interviews this afternoon, but I will say that I am comfortable with the attention to detail that has been given to these regulations, the attention to detail that has been given to the GLI standards and conforming them to the Massachusetts statute. I am more than comfortable moving forward. And I appreciate the assistance of GLI, certainly Katrina, who has given this her full attention in, not so ideal circumstances. She's relative to, her unavailability over the past several weeks. So I think we are in good shape on these to move forward. And I know Commissioner O'Brien, you asked to hear from me and Katrina, but I would ask Todd to jump in and share his sense of whether we are ready to move forward, whether he's comfortable with these as they are drafted.
Oh, I was going to ask my fellow commissioners if they were comfortable. Commissioner Hill?
Well, can I just see, my comfort level depends on those answers, Madam Chair. So if we could if I could hear from legal that they're comfortable, then I'm good to go. So
just to bring something up real quick, and I know this isn't on the agenda for today, but in the sports wagering account regulations, that we drafted and submitted, that includes the approved types or allowable types of funding your player account. So that aspect of the credit card account or the prohibition on the credit card and extensions of credit is reiterated in that chapter. And we can always elaborate further on it if there does need to be a regulation put in within the confines of that particular chapter, as opposed to appending the modified GLI 33. It might make more sense to make those modifications in that area.
Okay. And then I just saw the article. It was Iowa. It was Caesars Sportsbook. Iowa fined them $60,000. They allowed credit cards to be used on their site. That's what caught my eye.
There was another one, Eileen, too, in Iowa. And to answer your question, what I found is people were purchasing debit cards with credit cards.
Right. So it's another one step away, right?
Yeah, it was the one step situation.
It's like a different scenario for one step away.
So I guess the question too, and definitely that is a question you're gonna have to get resolved, is how far is that step for that credit card purchase? Because I mean, what's to stop me from going to a bank and getting a payday loan and taking that money, going to a casino or sports book and placing a wager? I'm not using a credit card to place a wager, but I use some sort of credit extension somewhere down the line.
And the prohibition, if my memory is correct, and then I hate to quote law from memory, is that the casinos are prohibited from the operators, are prohibited from accepting credit cards. It doesn't mean that a consumer can't use a credit card in one of the many ways you can get cash to then use on a sports wagering transaction.
Right, and that's a question I'm sure the five of us will have in terms of if the purpose is responsible gaming, at what point do we draw the line to say, getting the gift card, the prepaid gift card, or getting the Venmo pass through is too close,
And one thing too to talk about your available funding methods is those methods could be, there's always a provision where when the operator presents it, they're presenting to the commission their internal controls of available funding methods and any controls used to mitigate or to ensure that they're only offering the approved methods. So say for instance, you might have someone who operates in multiple states who allows credit card acceptance. And so like Connecticut, for instance, they allow a credit card to be tied to your account. But once the player crosses, if the player is funding their Massachusetts account, they're not going to be using a credit card.
So can I turn back to Commissioner Skinner? You suggested that we turn to Attorney Grossman. I guess I assume that given that this was your agenda item, that you were comfortable with the recommendation to go forward today on this.
I am, and I stated that, Madam
Well, I
Chair.
actually am talking to Attorney
No, but
Grossman.
then I wanted to hear from legal, and so that's why I think she had turned it to Todd.
I'm turning now to Attorney Grossman. Thank you, but I didn't want you to think I was bypassing you. I made the assumption that you're all set. Go right ahead.
Yes, thank you. No, I appreciate that. Yeah, I am comfortable with the draft. I think it was well done. Certainly Mike and team have an expertise in this particular area. These are their recommendations. We have looked through them. There were a couple of tweaks that were proposed along the way. It is interesting just to note, and this doesn't answer your question directly, but if you picked up on this, that there are references to internal controls and a few other things in there that we will have to ensure are reconciled with the coming drafts that are going to appear before you shortly. So there is certainly some buttoning up and reconciliation, but as far as the actual content of the draft that you have before you, I am comfortable moving ahead with this. There will be some trial and error perhaps with this and a lot of the regs that we'll have coming before us, and we will have to be comfortable making certain adjustments as we go. But there were certainly no glaring issues that jumped out at me that would have me recommend that you pause on this one at the moment.
Thank you.
Commissioner O'Brien and Madam Chair,
One minute, guys, we're talking over each other, and I need to make sure we don't talk over each other, please. It's just a matter of coordination, and the reason why I stopped is because I can see other people wanting to speak. Commissioner Skinner, do you want to go ahead? Or I was going to actually, I thought Commissioner O'Brien wanted to go ahead next, so.
No.
Okay, Commissioner Skinner.
Commissioner O'Brien asked about Katrina's comfort level in moving these forward, and because I don't want to speak for her, I have a text message directly from her saying that she is okay moving these forward.
Yeah. And I felt like she made that representation to us too. She's been along all the way with you. Okay, is there somebody, okay, Attorney Gross.
Madam Chair, if I may, I just add one more thing that I think everyone already knows, of course, but is helpful in this context here. This is, of course, the first foray here into these regs. If you adopt them by emergency, they'll go through the formal promulgation process. We will certainly have another opportunity to look at them. We'll put them out for public comment. So if there are any issues that anyone else spots and they want to bring to our attention, there's an opportunity to do that. And so I think this is a good time to, if everyone is comfortable, to just get the process moving ahead in this way. And we can always come back in the coming weeks and months and make any adjustments we need to.
Commissioner O'Brien.
No, that's good.
You're good?
Yep.
Okay, so again, if we've answered all of our questions, the GLI, excellent presentation today. For me, it was my first time to really review it with you. Very, very helpful. Commissioner Maynard, do you have any questions for GLI?
No, just to thank them and to thank Commissioner Skinner for her insights also. Very helpful in making a decision.
Of course, we have 2 more sections to go before we congratulate everyone too much.
So at this stage, I guess I'm wondering, we haven't broken them out, or do we?
Well, that gives me time to thank Katrina too, even though she's now not.
So, oh, I thought that we had scrolled through to the conclusion of that one. So we don't vote on this one now?
You can. I think it would be okay to wait until we get through everything and then take a kind of collective vote. So just let me, oh, sorry, Madam Chair.
No, I just want to, so everybody's all set, then what are we moving on to next?
Yeah, so I was just going to kind of calibrate everyone here. So we got through item number, it's 4B5. We're going to move on to B6 now. And so B6 is the kiosk part of the proposal, and it comes in two parts. One of them is the real substantive piece. The other is more of a kind of administrative part. So you'll see you have before you, it's 243.0. I'm sorry. O2, which is the area where we will reference over to 143.07. And that is the section of the regulations where the kiosk standard, GLI 20, is adopted by reference with amendments. And it's made applicable to sports wagering. So this is obviously a critical piece of it too. I think we actually got through a really huge piece of it already with the GLI 33 piece, but the next two parts that are coming up are equally as important. So there are these two more parts that we would like to try to get through today. And I'll turn things back over to Mike to talk about GLI 20, its adoption, the distinctions between the 2011 and 2019 versions, and what it all means. So, Madam Chair and Commissioners, if I may, I turn it back over to Mike.
Thank you. Commissioner Skinner, again, I apologize for not thanking you because we worked on the assignment and I know how interested you are in technology, so I'm thrilled for you. If there's anything you want to premise here, then go right ahead before we start with GLI.
Thank you, Madam Chair. No, I'm good. We can move right into GLI's presentation.
Okay, thank you. And turning to Mike, thanks so much.
Okay, so basically this doesn't have a large like breakdown where you've got you need a markup document. Fortunately, the adoption of GLI 20 is fairly simple, fairly light touch, and basically mimics what was already previously adopted for GLI 20 in section 143.07. What I do want to bring up, what I kind of mentioned, was that GLI 20's modification in version 2.0 did expand the functionality of the kiosks to handle account management and sports wagering or event wagering. And what we did too is we streamlined the layout and the format of the standard to focus more on the aspects that are going to be at the kiosk level and kind of defining our software requirements for the kiosk to say that for many kiosks, and especially in sports wagering, there is two aspects, really. There's the front end aspect, your physical kiosk terminal, the thing that the player interacts with. And then there is what we refer to as a back end platform, a back office platform. And that might be a server that is tied, either built in directly into a system like a sports wagering system, or it might be built into some sort of other monitoring system or server-based system. And that is basic. And the other thing that we wanted to do too is we wanted to streamline our references to GLI 11 for handling things that the common technologies that were utilized between both GLI 11 and GLI 20. In particular, your bill of validators and your printers and your coin acceptors and hoppers and the like. And we wanted to kind of draw that parallel directly to this between the two standards, such that, you know, for the purposes of testing, you have a consistent set of standards between both GLI 11 and GLI 20. Because we did update GLI 11 after GLI 20 1.5 came out, and we wanted to ensure that there was consistency between the two. The last thing I want to bring up is we included a statement in here in GLI 20 that specifies that this only applies to proprietary developed hardware and software. It doesn't apply to any sort of off-the-shelf components It does apply to the modifications made to off the shelf. We refer to as modified off the shelf, but we didn't want to apply it to components that were literally off the shelf. And this is critical for something like kiosks used for sports wagering, because kiosks used for sports wagering might use a commercial printer as opposed to the type of printer that you'll see in a casino, a ticket redemption terminal, your Tito voucher, for lack of a better phrase. So this is basically the high level summary of changes that was made to GLI 20 to modernize it and open it up for its usage for sports wagering and other regulated activities.
Okay, so that's, and again, so just to come back to the drafts momentarily. So there's two drafts before you for consideration here. The first is the draft edits to 205 CMR 143.07. That's the red line version where the standard is updated, as Mike just described, from 11 to 19, and then a few edits are made. And then there is the draft to 243.02, where you'll see it merely just says that the sports wagering operator and sports wagering vendor making use of a kiosk for sports wagering shall comply with 143.07. So those are the two drafts before you that cover the kiosk situation. Okay, if we're good with that, we can move on to 244. So 244, just by way of refresher, covers a lot of the administrative aspects, if you will, of the technology and the use of the equipment. It talks about the certification process, change management, and all of those things. The only note I'll make before turning back to Mike to talk about this a little bit is that you'll see at the end is 244.06, where we note that that will be reviewed separately. So that language, you'll recall, the commission has already adopted. That is the part that talks about essentially allowing independent test labs that are certified under the gaming rules to become certified under the sports wagering rules as well. And we did that in the early days, you may recall, in order to be able to contract with GLI to do what they're doing right now. So that's part 6, and that's why it's not included in this draft, but when you see the final version, it will be in there. Any questions about that, or are we okay to jump right into the draft? Okay. Okay, so Mike, if you will, we can kind of pick it up at 244.01 and maybe just take a quick walk through our draft language.
Sure. I want to share this. Can you see my screen now?
Mike, if you're able to make it a little bit bigger, that would be great for the commissioners who don't have it in front of them.
I am working on it.
I know, there we go. That's good, that's excellent.
Okay, so basically 244 is heavily based on 144. So we parroted a lot of the layout and requirements from 244 within, from 144 within 244. The first one section we talk about is sports wagering equipment. Basically, we're defining sports wagering equipment to cover any sort of equipment that is used for sports wagering, specifically for the operator. That includes your sports wagering platform, your kiosks, any sort of equipment. And we've seen this definition from other jurisdictions such as Ohio and Wyoming and Colorado and the like. The other thing too, we wanted to define that, sports wagering equipment doesn't necessarily cover things like the internet or any sort of intermediary software that connects to the bank. So we're not going to consider Apple iPay to be sports wagering equipment if they're using Apple iPay to fund a sports wager, for instance. And any order device. So for instance, your mobile phone is not considered sports wagering equipment. Now 242, we talk about testing and initial approval or testing and approval for initial and for critical updates for sports wagering needing to be tested by an independent test lab. And we talk about the operator or the vendor providing the lab with any sort of documentation or materials necessary. And as Joe Carlin discussed earlier, this would include witness build for source code verification and the like. And the reason why I say sports wagering operator or sports wagering vendor is because what we've seen in sports wagering is sometimes we'll have an operator develop their own platform or software equipment, and everything is submitted under them. So, you'll have someone like Caesars, who is an operator, and they have their own kiosks, they have their own server, and everything like that. And then you'll have another operator out there who will be an operator in name. So an example would be MaximBet. They have a partnership with a vendor who, they're just a name that they slap onto vendors' platform. And just for vocabulary, real quick, you might hear the term B2B, and a B2B would be a sports wagering vendor. So that's why we say sports wagering operator, sports wagering vendor here. But so I don't get too lost in the weeds. The next section we talk about if it meets the expectations set by the technical standards, which would be from 243, as well as like any other requirements set by the commission, the lab will certify the equipment. And certification can't, the operator can't launch without any sort of certification or modified equipment, critical modifications to equipment without certification. Number 4 talks about the commission side of things, or once a sports wagering system is approved by an independent test lab, it's still up to the commission to approve that certification, to take that certification and approve the sports wagering equipment. And we copied a lot of the wording that was from 144 into here for that purposes. Now, number 5 ties in the gaming technology lab, which might require any sort of additional testing if it deems necessary. And that could be something like on-site testing of the kiosks before clearing them for launch, or it might even involve Katrina and her team hopping in a car and doing their own spot checks of geolocation on top of what the lab has already done, or what the ITL has already done. And then number 6 was copied straight up from 144, where it talks about the operator or vendor notifying the commission if it's aware of any sort of negative action in another jurisdiction. Now, 244.03, this section talks about integration and change management. And integration is going to be, something that's critical for your third-party service providers. So this would be your payment provider. This would be your geolocation provider. This would be your identity verification provider. And what this is essentially saying that, the operator at the end of the day is responsible for everything. And that integration testing for any sort of new components would need to be done by an independent test lab. So say, for instance, you know, you have a sports betting provider, a sports betting operator, and they're using identity verification company 1. And they go, I'm not friends with these guys anymore. I want to use identity verification company 2 now. Well, that integration testing would need to be done by an independent test lab. And, you know, that's outside of all sorts of the whole license vendor thing. That's unrelated to this. So this is what this section is talking about. Now, number 2 here is where things get a little interesting, where we're basically talking about change management. Now, the thing with sports wagering is it's not a slot machine. It's not a machine that you seal up on the floor and nothing is going to change in its environment and it's just sealed. A sports wagering system uses components all across, you know, all across the realm. It's not a air-gapped system. It's on the internet. It uses the internet to communicate feeds, even for, you know, your Cat 1s and Cat 2s. There's the aspect of the internet. And with that in mind, there's constant updates to these systems and constant improvements to these systems. And as opposed of, you know, locking down everything and requiring everything going to a lab and being certified for every little change in that environment, what this process focuses on is identifying critical components and a procedural process to identify updates that need to be evaluated by an independent test lab, components that don't need to be updated by an independent test lab. For instance, changing the colors because Thanksgiving's coming up. Say you've got Barstool and they're like, I want to change the background to Christmas colors because, you know, it's a season. They don't need to resubmit to an independent test lab and have that evaluate and go, yeah, it's good. They can make such changes. And I know it's very superficial, but it's something, you know, they enjoy. The other thing too is there might be some critical updates. And basically the whole point of the critical updates is there might be a breach in the internet, you know, a data breach or something, and they need to update their servers right away. Like, oh my God, I can't believe we just discovered this. We need to patch this right away. Well, we can't just run this through wait until the lab says it's good to go and wait for the commission. We need some sort of emergency patch process. And so this is all covered within our GLI CMP, which is our change management program guide. And it's posted on our website. And it identifies the various levels of, it identifies various things. First off, this is something that is tied back into GLI 33 when it talks about server security and technical security controls and requiring your annual security audits. And it also ties into identifying, you know, maintaining a critical asset registry of all the critical sports wagering equipment or system components, and goes through a process of level 1, level 2, and level 3 changes. Now, level 1 changes will be completely cosmetic or something that doesn't really affect anything. We term that as no effect. Level 2 would be something that has low effect, and level 2 would be something minor, which, you know, it does affect a regulated process, but it's more of a regulatory enhancement. And then you have level 3, which is a critical process, which is like changing out your geolocation provider, or, you know, fixing a critical error in your reporting, or adding a new feature, adding virtual events once the concept's approved by the commission. You know, and based on those levels would determine whether or not those changes go to an independent test lab need to go to an independent test lab. So general consensus is level 1 doesn't need to go to a lab. But as far as level 2 and 3 is concerned, those get reported to the commission. And it's up to the commission to make the call to basically say, yeah, this change is minor and can go and can be launched. Or hold on, you need to get this tested by independent test lab first. And that is going to be on a case-by-case basis for level 2 and level 3. And the other aspect there is, even if you review a change for level 3 and are like, you know what, this doesn't need to be tested prior to launch, there is built in within the GLI CMP a requirement that the changes do need to be tested. It's just they don't need to be tested prior to deployment in the live production environment, basically the system that the users are interacting with. And with regards to all these changes are recorded in a log. And section B here, it basically says that all these quarterly change reports need to be evaluated by an independent lab. And they're ensuring that these changes are properly classified as level 1, level 2, level 3. And the higher focus is making sure that things that weren't incorrectly reported as a level 1 and therefore slip through the cracks of whether or not they need to be evaluated by an independent test lab. And item C here basically reiterates an annual recertification of the entire system. And the reason why I do this here is because you might see a system and you'll have a mod of a mod of a mod of a mod of a mod, etc. But the annual recertification reestablishes a baseline saying, okay, these are mods to the 2022 version of this platform. And now this recertification is the 2023 version of the platform. And then from there, mods are going to be made from that. So, and the other thing too to bring up here is the reason why we have this annual recertification is to reestablish your independent verification of signatures for the entire system. So, when you look at a letter, you're going to see version 1 of a system. And when these change logs are submitted, there are going to be these logs, and they'll say if there's any signatures that change in those critical components. And if there is a letter from a lab for a level 2, level 3 change, that will also have the signatures of the critical components that are changed. But this annual recertification establishes a full, fresh baseline of the system. It's like if you got it straight off the lot. So it'll have fresh signatures, the fresh letter. It's just new. So 204 or 24404 just talks about the requirements for testing regards to the type of report we issue. And this is copied from 14404. This is all the information copied from 14404. Same thing with 24405. A copy is from 14405. And that's it for 244. As Todd mentioned, 24406 has been previously discussed and whatnot.
Thank you, Mike. Commissioners, questions for Mike? Is anyone leaning in? Commissioner Brown, are you leaning in? No? I have a question if there's no other question right now. Is there any reason not to adopt the annual review recertification process? Has there been any pushback?
I mean, multiple jurisdictions have adopted annual recertification. It's become standard. I mean, Indiana, Illinois requires it twice a year, but it's more common to be once a year. So, Indiana, Wyoming, I believe Michigan, not 100%, but a number of jurisdictions do require annual recertification for the purposes I mentioned, establishing the baseline.
And also to clean up the records, it's analogous to closing out your year-end books. Because this is dynamic, With a slot machine, we test all the software on the machine, all the games that are on that machine, and you get a signature, and that machine might sit there for 15 years and never change. Right? It's much more dynamic. And if you can imagine trying to trace your way through 3 years of change management patches, it could become a mess in a hurry. So it's kind of like closing your books at the end of the year and starting a new fiscal year.
Just a follow-up, and so Illinois, was that by statute that they had to do it twice, or that's just their?
I think it's by regulation.
Okay. Well, commissioners, I think the recommendation today is for annual, right?
And Arizona requires it once every 15 months. But Arkansas requires it annually. Connecticut, DC, Indiana, Iowa. And et cetera.
Thank you. Other questions for Mike? Okay. Commissioner Skinner, you were involved with this, following on this as well with Katrina. Do you want to add in? You're all set then. Okay, I got a thumbs up for the record. Now, Todd, do you want to add in? And then we have really the full GLI groupings today for consideration.
Yes, so that's right. No, I think that I guess I would just add that I am comfortable with these drafts. I think they were certainly prepared by the best people equipped to do this. We have looked at them. There are parts that I've looked at with outside counsel directly, and we're comfortable with certainly what they say. I think they're really well done, actually. Of course, like before, they'll be put out for public comment, and if there are particular areas of concern, I'm sure they will be flagged, and we will, of course, have an opportunity to go through them in a little more detail, or I shouldn't say more detail, but we go through them again, just to confirm that. But otherwise, I'm comfortable, if you were to move forward with these today, to move the process ahead, and we can kind of take it from there. So there are 4 drafts before you. There's 243.01, 243.02, 143.07, and then 244.01 through 05. There is a small business impact statement that is in your packet at page 173, I believe, which covers all of them together. There aren't separate statements for each of them. So if you are prepared to do so, that would be the request.
Commissioners, are you prepared to move today? If so, I'll take a motion. Commissioner Skinner, are you prepared to move today or no?
I am prepared to move, except I am not prepared to move on the second component of the motion that speaks to emergency promulgation. So I'm happy to move on the, moving these forward for public comment, but.
All right, so I'm hearing that we don't, why don't we just go over the impact of not using the emergency regulation? Todd?
Yeah, so if we don't do it by emergency, that would mean that they will not be in effect for 60 to 90 days. And I'd have to pull up my calendar here, but you can kind of map out what, yep.
Todd, I can help you out there. Sorry, just because I ran this just so we would have a sense of the date. These would go into effect on February 17th if we were to file in the ordinary course tomorrow.
Okay, do I have a motion?
Madam Chair, just for discussion purposes first, If we could do these individually, which I like to do, I would make a motion for the first one. If that would be all right with the rest of the commissioners.
I'll take a motion.
Okay.
Thank you.
Madam Chair, I move that the commission approve the small business impact statement in the draft 205 CMR 243 as included in the commissioner's packet and discussed here today.
Second.
Madam Chair and Commissioners, if I may, I just want to clarify that includes 243.01 and 243.02.
I don't have it in front of me.
Yes.
So your motion is amended to reflect Councilor Grossman's inclusion, correct?
Correct.
Commissioner Hill? Thank you. Do I have a second?
Second.
Could you restate the motion, please, Commissioner Hill?
I move that the commission approve the small business impact statement and the draft 205 CMR 243.01 and draft 205 CMR 243.02 as included in the commissioner's packet and discussed here today.
Second.
Okay. All right. Thank you for the read. Okay. Any further questions on that motion? Okay. Let's go ahead. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Maynard.
Aye.
Commissioner Skinner.
Aye.
And I vote yes. 5-0. Okay.
Madam Chair, I move that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Are there any questions or edits on that motion? Okay. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Maynard, Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. 5-0. Thank you. All right. We'll do it in the next round. Commissioner Hill, you're on a roll.
I just want to be clear that I'm making this motion. This is for 205 CMR 143. Todd, is that accurate?
Yes, 143.07 specifically.
Thank you. Madam Chair, I move that the commission approve the small business impact statement and the draft 205 CMR 143.07 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Any questions? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Maynard. Skinner, I'm so sorry. I'm going around counterclockwise. Commissioner
Yeah,
Skinner.
we seem to have a new order today, but aye.
There isn't though, really. Might be a little fatigue, Commissioner Skinner, and that's about it. Commissioner Maynard.
Aye.
And I vote yes. 5-0.
Madam Chair, I would move that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Any questions or edits on that? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes, 5-0. And Commissioner Hill.
Todd, just being clear,
Yes.
we will be doing 205 CMR 244.
Yes, it's 0.01 through 0.05 specifically.
Thank you. Madam Chair, I move that the commission approve the small business impact statement and the draft 205 CMR 244.01 through 0.05 as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner. Okay. Any edits or questions on that one? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0.
Madam Chair, I move that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that the staff shall be authorized to modify chapter or section numbers or titles, to file additional regulation sections as reserved, or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Thank you, Commissioners. Any questions or edits on that one, Commissioners? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. How'd we do, Todd?
Now, Madam Chair and Commissioners, I'll join you in thanking Mike, Kevin, and Joe and the whole team for their great work on these drafts and helping us reach this day. Our work is certainly not done. This was a huge step forward, though, for us all. And so I think there's a lot of great work that went into this. So thank you all.
Thank you, Todd and commissioners, and special thanks to Mike Robbins. He's always a joy to work with. He has meticulous attention to detail. He catches things that three others of us sometimes miss, and so it's always he's the captain of this particular aspect of the team. And but it was as always a team effort, and along with your staff, Madam Chair and Commissioners, they are wonderful to work with, and we're really enjoying the engagement. So we appreciate it.
Kevin, does that get us through our third part of GLI school, or do we still have to go through that?
Yeah, I think Matt and Gabe are working on diplomas of some kind, and maybe
Kevin,
we'll have special robes made up for February 1st or whatever date the target is. But
Yeah, Mike, you did a great job. Could be a professor.
Thank you, Mike. I think, Kevin, we're all fearing the test that they're threatening us with. We want the virtual, but we just don't want the test. That's all. And we need to thank your colleague who left earlier. He too was very, very helpful on the testing process, Joe. So thank you to all of you. I know that we are benefiting tremendously from GLI's work here. We really appreciated the training and look forward to the continued engagement. Commissioners, do we have anything else for the GLI before we turn to Director Lilios? Legal team, are we all set?
We are set. Thank you very much.
Okay, great work, Commissioners. Okay, so now we have one more item on the agenda. Director Lilios, you got an update for us.
Hi, good afternoon. The update is brief, but very important, and that is that all eyes are on Monday. Monday is the application deadline for the operators. So this is an important time for the operators. We have been meeting with them in groups by their category. We have been answering their questions, and I know that they are working hard on their applications now. And as for our team, we are working hard to make sure that Monday goes smoothly with that initial processing. So really the big the big process update is all eyes are on Monday, and we continue to plug away at regulations and other preparations, but everyone's focused on Monday.
Any questions for Director Lilios? Okay, any commissioners updates? All right, then I need a motion to, yes, Commissioner Hill.
I don't have a commissioner's update, but as you were very kind to allow me to put off the minutes until the end of the meeting.
Thank you. See, I needed the reminder. Thank you so much. Okay.
So Madam Chair, I would move at this time that the commission approve the minutes from the May 12th, 2022 public meeting that are included in the commissioner's packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Everybody's had a chance to review them. Commissioner O'Brien, we waited for you. You had a chance, I'm assuming.
Yeah, I had seen them before.
Excellent. Okay. No edits in motion. All right. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Abstain.
Thank you, and I vote yes. Thank you so much. Before we get the motion to adjourn, I want to just pause and take time to thank, and I know she's not even listening, but Crystal Boschman. This has been an extraordinary effort on her part to keep us organized with the materials. She's been working and is so appreciative of all of the work that she does with each division to keep us organized. I know she's off at a meeting right now. Todd, and I know the legal team has been working so closely with her. We are on, of course, multiple meetings. We knew that coming in, and she hasn't blinked. And so for that, I just want to be on the record of thanking her in her role and the support she provides us each and every day. And I'm terribly grateful for that. So I could thank each and every member of our team. I just today wanted to highlight Crystal as she continues to plot ahead of us. Okay, so thank you. Anything else, commissioners? All right, then now I do need a motion.
I move to adjourn.
Second.
Okay, discussion. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes. Thanks, everyone. Thank you to GLI. Wonderful meeting. Very, very, very helpful. Excellent work, guys.